Court does call the case of the People versus Diamond Rivers, or Byers, excuse me.
Morning, Honorable people.
Okay, this is a good start. Good of you to
I do feel lucky.
What?
I feel lucky. I didn't hear the name though.
She's right behind you.
Oh.
Your client, Diamond Byers.
Edward.
Hello, Miss
on
Byers.
behalf of
You guys
Diamond
need to
Byers.
switch sides. This is not
Okay.
starting well.
Oh my God. Hello.
Good morning, Your Honor. I'm asking for an adjournment today. I got appointed to the 2 new matters and I'm waiting for some discovery.
Your name, ma'am?
Diamond Byers.
All right, thank you. All right. We were trying to, never mind, she's talking to Kilowatt. Daisy. Probable cause conference will be adjourned to January 29th, 2026, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Byers. Court does call the case of the People versus Michelle Campbell.
Morning, Honorable people.
Brian Bowling on behalf of Ms. Campbell, Your Honor. State your name for the record, please.
Michelle Campbell?
Judge, we do have a resolution which will require a no contest plea.
And you just gotta get the paperwork.
Yes,
in.
please. So if I could get a week if possible.
Probable cause conference, January 15th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
All right. How you doing, Miss Campbell?
I'm doing well. How about yourself?
Not too bad. I get to
That's
see you
good.
next week, right?
Yes.
All right.
You definitely will.
All right. Thank you, man.
And I'll
Have a
see-
blessed day.
Good. Court calls the case, People versus Bobby Tennyson. Seriously? No, that one's gone. Court calls the case of the People versus Gary Coward.
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Gary Coward. Who's approaching, Your Honor?
Your name?
Gary Coward.
Thank you. You're seeking an adjournment?
Correct, Your Honor. Couple of weeks will be fine, just so Mr. Chavalowski can get caught up and potentially resolve it at the district court level. Thank you, Your Honor.
January 29, 2026, 9 a.m. Bond continues.
Thank you.
Court calls the case, People versus Joshua Wara.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Wara. Mr. Wara, will you state your name for the record?
My name's Joshua Wara. It smells like blunt smoke and cologne in here, something like that. Sorry about that, Mr. Simpson.
It's okay.
You doing all right?
Me?
Yeah.
I'm great. How about yourself?
Nice to see you today, man.
Good to see you. All right.
Your Honor, our office is in receipt of a report dated December 10th,
Okay.
finding that Mr. Wara is incompetent but is restorable. I did prepare an order. We would stipulate to the finding of that report.
What's that mean?
Anything from the people?
And there's some bullshit.
Oh, Mr. Wara, we talked about that before. We don't use that language, right?
Yeah, I'm sorry, Your Honor. I just
All right.
don't agree with having to go.
No, I understand that. Just don't use that language. You may not agree with it, but that's what I've got in front of me, okay?
All
All
right.
right?
All right. Sorry about that, Your Honor.
It's all right. What I will do, given that that's the information at this time, and your attorney will explain everything to you, okay? So don't get upset by it. I'm gonna, all I have.
You think I need the forensic center? I got a Neuralink attached to my brain that's causing the schizophrenia. It's a telepathic communication device that also uses visionary hallucinations, which means the person I'm connected to can see everything I'm seeing, but I have no glasses, so it's just a blur to them.
Got it. Okay, so you make sure to explain that to all of the people that are gonna see you now.
What, at the
okay?
forensic center?
Yeah, at the forensic center, and then there may be other people that.
How
may
many
talk-
days am I getting in there?
Well, I don't know yet, but what I'm gonna do is I'm gonna find that you're incompetent at this time, okay?
Fuck.
And then,
Hey, don't.
Laura, remember,
Sorry, Your Honor.
okay. I'm gonna do that, and then I'm gonna set a review hearing so that you'll be able to come back to me at 90, please.
All right.
90.
April 2nd at 9 a.m.
All right, so I'm gonna set a review hearing for April 2nd, 2026, 9 a.m. So you'll get to come back and see me
All right,
and
I saw
let me
you
know
on
what
court
all
cam,
these people
dude.
said, huh?
I saw you on court cams, dude.
Did you?
Yeah, I saw you on court cam.
Did I look good?
Yeah, you was looking beautiful. How about?
All right, thank you. All right, take care. I told you, Alan, I have friends. Court calls the case, people versus Raisha Anderson.
People.
Morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of Bryce Anderson.
And Assistant Public Defender Chelsea Ridgefield with and on behalf of Bryce Anderson on other case, I'm on 5640.
I'm on 5330, Your Honor.
I know. You were pushing mystery fields out of the way. Your name, ma'am?
Bryce Anderson.
All right. You are both requesting an adjournment or what are we?
Yes, Your Honor.
All right. I don't have her print sheet. Probable cause conference in these matters will be adjourned January 29, 2026, 9 a.m. Bond in these matters will continue.
Permission to speak, Your Honor.
Pardon?
Permission to speak.
You already are. Go ahead.
Respectfully, my client missed her court date yesterday. She showed up late. She indicated that she did put in a warrant recall, and we're just trying to see if we can get that warrant recalled.
This is a case from yesterday?
From yesterday.
Okay, so of those 109, I'm supposed to remember. I don't, so what are you asking?
It was a case from yesterday in which I had Miss Anderson actually had a case in which I represented her, Your Honor. I'm asking, can we recall the warrant from yesterday because she didn't show up? Or she
She's
showed
here
up late.
today, but she wasn't here yesterday. That's what
Correct,
you're telling me.
correct.
And now you want me to do something about a case that I don't have the file for from yesterday.
Correct.
And if I say no, what happens?
I'll say, can you please reconsider, Your Honor?
What hasn't?
The online recall that she did.
So she already did the online recall, but you haven't received an answer from us, right?
Correct.
So what will happen is it hasn't gotten to me yet, or my staff yet. So it should be taken care of.
All right, thank you, Your Honor.
You're welcome.
Appreciate it.
I always appreciate you too.
I'll
Take
see you
care.
this afternoon.
Okay, that's a threat. Court calls the case, people versus Devontae Connor Belcher.
Carolyn Foster Tucker on behalf of Devontae Belcher. Can you state your name?
Devontae Connor Belcher.
You're seeking an adjournment.
Yes, Your
Just
Honor.
appointed on this. Probable cause conference, January 22nd, 26, excuse me, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Tanisha at Akins.
Morning, Your Honor. Raymond Cook with people.
Assistant Public Defender Hannah Apple on behalf of Aiken to appear before the
Waiver.
I apologize. Looks like she went to the restroom. Thank you.
Or warrant her, one of the two. Court calls the case, people versus DJ Dan DeMoody. Did you see him, Mr. Mo- Today?
Good morning, Your Honor. Attorney Matt Hauser on behalf of Mr. Dan DeMoody. Poorly timed restroom break.
All right, where are we? Record should reflect we've had a bench conference in this case. My understanding is that the defendant is waiving his right to a preliminary examination.
Yes, that is correct, Director.
Mr. Dan DeMoody, you're waiving your right to a preliminary examination?
Yes, I am, Your Honor.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I understand, Your Honor.
And you understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
I understand, Your Honor.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. As to the circuit court arraignment, you waive formal reading, your client stands mute at this time.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
January 21st at 1:30 before Judge Conlon.
January 21st, 2026, 1:30 before Judge Conlon. Bond will continue. Thank you. They'll need to sign off. Yes. And then that needs to just get to Ann, however we do that. Thank you.
Thank you very much, Your Honor.
All right, take care, sir. Court calls the case, People versus Hiba Al-Shabani.
Brian Bowling on behalf of Al-Shabani.
Just knock him out of the way. Go ahead. Your name?
Hiba Al-Shabani.
Judge, we're asking this matter be set for a preliminary examination.
All discovery is complete.
Yeah. Don't speak.
20th. People have their witnesses available the 20th.
Yes, this.
Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Freshour.
Probably will not be in this courtroom. Yes, the same courthouse.
Bond will continue.
Thank you, Judge.
Thank you.
I'll give you a notice for that date.
Court calls the case of the People versus Giovanni Moot. 3 cases.
Good morning, Your Honor. James Fifelski on behalf of Mr. Moot on case ending in 1665. Who else has those files?
Who? Mr. Ballinger?
Mr. Ballinger.
Just a jerk.
Michael Gaddy, Assistant Public Defender for Mr. Moot.
And I believe everybody's requesting an adjournment of these.
That's correct, Your Honor, for discovery.
And we have initiated an investigation as well, Your Honor, so that's going to take several weeks. So I'd just be asking for at least 3 weeks here.
You want 3 weeks?
Yes, please.
Is that going to be okay on the other matter?
I have a conflict. I'll be in Dearborn District Court on the 29th. I can do 2 weeks. I can't do 3 weeks.
Okay, well, I suppose we can start with 2 and then go from there. I have no problem with that.
January 22nd, 2026, 9 a.m.
Okay.
Bond continue.
Thank you, Your Honor, and apologies.
Thank you, Your Honor.
We did initiate the investigation.
I think there were 3. And you might want to check just to make sure that one didn't get put in with that. Court calls the case of the People versus Malik Al-Sadi.
Okay, welcome.
And Stephanie Cannon, on behalf of Mr. Al-Sadi, could you please state your name for the record? Your Honor, I am asking for a brief adjournment. I do believe we're very close to resolution on this case. We just had to crank some things up the chain for him, so.
January 22nd, 2026, 9 a.m. Bond.
January 2nd.
Thank you.
You.
Court calls the case, People. Is he there?
Thank you.
Court, thank you, sir. Court calls the case, People versus Alan Rogers.
Morning, Your Honor. Raymond Cook.
Good morning, Your Honor, and good morning to your staff. Ferris Haddad on behalf of Mr. Rogers.
Thank you. And your name, sir?
Alan Rogers.
Thank you. All right, what are we doing on this?
Judge, he is scheduled to be transported hopefully tomorrow to an inpatient facility. So we're asking for a 4-week adjournment. After that treatment, he may have a way to keep this at district court.
So you're looking to adjourn this out about 4 weeks?
Yes,
Is that
sir.
correct, counsel?
Yes, Your Honor.
from the people, is that correct?
Yes, Your Honor.
Why don't we do it this way then? February 12th,
Okay.
2026, 9 a.m.
Thank you, Your
Bond
Honor.
will continue. All right, thank you. Thank you, sir. Good luck to you. Court calls the case of the people versus Renee Andrews.
Good morning, Your Honor. Assistant Public Defender Don Lieb on behalf of Ms. Andrews. Ms. Andrews, can you please tell the court your name, ma'am?
Renee Andrews.
Thank you. All right.
Andrew, we're going to be requesting an adjournment today in order to have some further discussions with Ms. Andrews as well as to review some media discovery.
January 29, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Christopher Thaxton.
Your Honor.
Andrew Childress, attorney on behalf of the people.
James Fifelsky on behalf of Mr. Thaxton, who is approaching.
Your name, sir?
Christopher Thaxton.
Thank you.
Your Honor, all discovery is in, and we would ask the court to set this for preliminary examination.
People have their witnesses available the 20th.
That's fine.
Preliminary examination will be set January 20th, 2026, 9 a.m. before Judge Moore. Bond continued. Thank you.
Thank you, Your Honor.
Stop. Court calls case people versus Rick Artuso.
Right here.
It's another Ballinger case. He's asking for an adjournment, so.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Artuso, Your Honor.
Mr. Artuso, can you state your name, please, sir?
Rick Artuso?
All right, he's waiting a response on this. What I will do, adjourn the matter out to January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Artuso.
Okay, thank you.
Court calls the case, people versus Mark Tipsword.
And then on behalf of Your Honor.
Proceeds to substituting in for the Washtenaw County Public Defender's Office, appearing on behalf and with Mark Tipsword.
And I sign these substitutes. All right, what are we doing?
Your Honor, may Ms. Senator and I approach, please?
Okay.
What's that check? Your son said you wanted to check that for appeals.
Okay. On this matter, what I'm going to do, and the record should be at a bench conference, probable cause conference will be adjourned to January 29th, 2026, 9 a.m. We also discussed in some of the issues regarding the bond violation. The courts is satisfied that there was not actually a bond violation in this case, and so I will not be finding that he violated his bond. His previous bond will be reinstated. I'll need a new GPS order so that he has that on him prior to release. Yes,
And Your Honor, I'm sorry, did
I
you
think
say January 29th?
yes. Will
And
that work?
Is there, that's perfect.
Okay.
For that.
All right. And so we'll do that with his bond and we'll reinstate that and then we'll check, my staff check on that other hold. All right.
Thank you.
Thank you.
So you're gonna get.
Court calls the case, people versus Charles Cobb.
That's other.
Yeah, he's gonna have to.
Andrew Childress, attorney on behalf of the people.
Good morning, Your Honor. Christina Saxon, standing in for Attorney of Record Kyle Cradell with Mr. Cobb. Mr. Cobb, please state your full name for the court.
Charles Cobb. Thank you. You're asking for an adjournment.
Yes, Your Honor.
Additional discovery. January 22nd, 2026, 9 a.m. Bond continued.
I'm sorry, Your Honor.
22nd.
Okay, thank you.
You're all set, sir. Court calls case People versus Joseph Bonville.
Did you say Bonville?
Bonville.
Raymond Code for the people.
Tina Saxon for Joseph Bonville.
Oh, there's two of them. This is
Joseph.
your name, sir?
Joseph Fonda.
All right, that's right. All right.
Your Honor, originally, there was a request for an adjournment for another PCC, but we're going to instead ask for a preliminary exam date. I do believe I have all discovery.
All right, here you go. People have their witnesses available on the 20th. Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Margaret Patowski. Is she, where is she? Oh, is she here? And she's not there right now. All right, we'll wait for her to appear back. Court calls the case People versus Shayna Desir.
Morning on the Raymond Code for the people.
Desir,
She's trying to shut the door.
she what? She's outside the door.
Thank you.
Well, I'm not holding the hearing out there though.
We'll come back.
Seriously?
Morning, Your Honor, Christina Saxon for Shania Desir. Ms. Shania.
Your name?
Tonight is a
You're requesting an adjournment?
For both cases.
Here, maybe speak to the officers. Will 3 weeks be enough time for you to get that done?
Yes, Your Honor.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor. Have a good day.
You do the same. Court does call the case People versus Mary Barney.
And then on behalf of people, Assistant Public Defender Chelsea Ritchfield with and on behalf of Mary Barney. Please state your,
Mary Barney.
Thank you. All right, what are we doing?
we are asking for a preliminary exam in all cases.
In both matters?
Yes, Your Honor.
All right. And discovery is complete in both cases?
Your Honor, on the arson case, we're still awaiting one more supplement report with the re-interview of the victims. I'm hoping to have that by next week.
We would ask for a preliminary exam as soon as possible.
Well, I don't mind setting a preliminary examination. It wants that report. If you don't have that report, you're not going to be entitled to an adjournment based upon that.
Would you like to wait for it or have it?
I don't know what that means.
So if we get to the date of the preliminary exam and we don't have that report,
You hope to have it next week. So what I would then suggest or maybe propose to is adjourn this out. I'll give you a 1 week adjournment on this. Then you can look at the report, go through that with your client, figure out it strategically or whatever, what you want to do, and then I could set the exam. But
I guess so.
that's fine, Your Honor.
that'll work? Okay. The probable cause conference in this case, January 15th, 2026, 9 a.m. Bond continue. Thank you. Yeah. Court does call the case, People versus Margaret Petoskey.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Petoskey. Your Honor, I reached out.
It is Miss Gaines. It is a pleasure seeing you.
It is a
I
pleasure.
haven't had her before me for a while.
It is a pleasure to see you.
All of these people were making me miserable, and now I'm happy. Thank you, Miss Gaines.
I am glad to be
Miss
able,
Petoskey goes, that's good.
I'm glad to be able to bring that joy to you.
All right.
Ms. Petoskey.
Ms. Petoskey, can you state your name, please?
Margaret Ann Petoskey.
Thank you. All right, what are we doing?
Your Honor, I did reach out to the Huron Valley Women's Prison by email and by left a voicemail message, and I was unable to arrange an appointment to meet with Ms. Petoskey. I do have an offer to go over with her, and I anticipate at our next hearing, we will be able to move forward. So I'm requesting an adjournment.
All right. You told them you were Joy Gaines and they wouldn't let you in? Really? Oh, never mind.
I probably should
Never
have
mind.
said it was going to be. In
All right. Well, the 29th, you think that'll give you enough time to get in, see her and do it? Okay.
Yes, thank you.
So I will adjourn this out January 29th, 2026, 9 a.m. Bond will continue. Thank you, Ms. Petoskey.
Thank you.
Thank you so much. Have a great day.
You too. Court does call the case, People versus DeJure, Bond Sanders. Well.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Welcome back. Happy New Year.
Happy New Year.
I'm glad you chose the appropriate clinic to practice in.
Me
All
too.
right, permission to practice is granted.
Thank you. Your Honor, we are asking to set up preliminary examination.
In both cases?
Yes,
You want them set in both?
yes,
Yes. All discovery is complete.
yes.
People have their witnesses available the 20th? All right. Preliminary examination in person, January 20th, 2026, 9 a.m. That is before Judge Moore. In both cases.
Thank you, Your Honor.
All right. Thank you. Court calls the case of the People versus Demarion White. He's in zone.
Yeah.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Demarion White is appearing via Zoom from the juvenile facility.
Sir, please state your name.
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers have spoken as well as my client. We are asking for an adjournment till the 27th, I believe. 29th, I'm sorry, I got the date wrong, yes.
All right. Is there a co-defendant on this one?
Not that I'm aware.
There's not. Okay.
That's a different, I think you said that last time. It's a different case, Judge.
Yeah, I think you're right. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
All right, Demarion, I'll see you in a couple days.
Court does call the case, People versus Linda Bryant.
And I ask for permission for Ms. Bryant to sit down.
Absolutely. She looks at.
Your Honor, I'm Michael Gaddy for the Public Defender's Office for Ms. Bryant, Your Honor.
Your name, ma'am?
Linda Bryant.
Thank you. All right, what are we doing?
Your Honor, I'm asking for an adjournment in this matter to go over the information with Ms. Bryant. I have collected good contact for her today.
Oh, okay, very good. Probable cause conference, January 29th, 2026, 9 a.m. All right, bond will continue. All right, thank you, ma'am.
Here you go, Ms. Bryant.
Okay. I need to see her. I need to get home and get my shot.
You're all set.
Okay.
All right.
Okay. You remember me?
Yes, sir.
Okay.
Need your hand?
You gonna help her out? Or you just, what?
I'm getting moving. I'm going.
He didn't come over to you and say, get up and get out, did he? Did you say that to him? No? Okay, I'm just checking. Just want people treated respectfully. You know, okay. Court calls the case, People versus Melinda Baker.
Like to add the Assistant Public Defender on behalf of Ms. Baker, Your Honor, who I do believe is here by Zoom.
She is. Ma'am, if you could state your name.
Melinda Baker.
Thank you.
Your Honor, I'm asking for an adjournment of this matter. I have spoken with Ms. Baker. There is some investigation I need to do that's ancillary to this case.
You're doing okay. Probable cause conference will be adjourned then to February 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you, man. Court calls the case, People versus Jeffrey Bushinger.
People.
Ms. Cannon isn't working today.
Veronica Glenn on behalf of Mr. Businger, can you please state your name for the record, please?
Jefferson here. Thank you. All right, what are we doing?
We would like to set this for preliminary exam.
Discovery is complete.
Yes.
People have their witnesses available the 20th.
Yes, Your Honor. May I approach Ms. Cannon for a second?
Sure, come on up. Why you gotta bring Cannon now? Come on, Glenn. Glenn, get up. So we're still setting this?
Yes, Your Honor.
All right.
Sure.
Preliminary examination in this matter in person, January 20th, 2026, 9 a.m. That's before Judge Breshow. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Spencer Norton.
Good morning, Your Honor. Edward Dukes on behalf of Spencer Norton in 1768.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Norton on the other matter ending in 1856.
And Mr. Norton is refusing to join us.
He is. However, we were looking for an adjournment, so we'll try and get his presence here at the next hearing.
For the record, I did speak with Mr. Norton yesterday. He did ask that the matter with me be set for preliminary examination, but I understand him not appearing.
You'll need
Will
to be
adjourned.
here for me to do that.
Yep, so we will do that.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court does call the case of the People versus David Childs. Two cases.
Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Senior Assistant Public Defender Joy Gaines.
Happy New Year. Welcome back. Practice is great.
Thank you, Your Honor. I hope you had a good New Year.
Starting out, we're okay. Yes, I did. Thank you. Your name, sir?
David Childs.
Your Honor, requesting to adjourn this matter. We have yet to receive the police report in case ending in 2509, and media discovery in both cases are still not.
Yes, okay. Probable cause conference then will be adjourned to the 22nd, January 22nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus, is it Deja Banbury? Why even when she's not involved is there a delay in Cannon's cases? Where's Miss Banbury?
Veronica Glenn on behalf of Ms. Burnberry, can you please?
Your name?
Deja Monique Banbury.
Thank you.
Your Honor, we're requesting adjournment in this matter.
Do I have a green sheet?
Yes, I think so.
Any objection from the people? January 29th, 2026, 9 a.m. Bond continue.
Thank you. Your Honor.
Thank you. Court calls the case People versus James Cobbs.
And on behalf of people.
Assistant Public Defender Davi Lebo on behalf of Mr. Cobbs, who's approaching. Mr. Cobbs, can you tell the court your name, sir?
James Cobbs.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Discovery complete.
It is, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Manuel Burnhouse.
Here, Your Honor.
Rock Docket, Assistant Prosecuting Attorney on behalf of people.
Monica Glenn on behalf of Mr. Barnhouse, who should be appearing by Zoom.
Yes. Sir, state your name.
Manuel Barnhouse.
All right. What are we doing on
Your
this?
Honor, we would like to request an adjournment in this matter.
Reason for the adjournment, I don't have a brief.
There are some new charges.
Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case People versus Davian Gavin.
And your children's attorney on behalf of people.
Hello, Defender Davi Lebo on behalf of Mr. Gavin.
Your name, sir?
Davion Lamar Gavin.
Thank you.
And Your Honor, we do have an agreement to waive Mr. Gavin's preliminary examination with an agreement to felony HIDA at circuit court.
So he's waiving.
Yes, Your Honor, and I'm having him execute the form now, and I have reviewed the relevant rights with him.
Sir, you're waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Examination having been waived, defendants bound over to circuit court, single count.
Thank you, Your Honor. We acknowledge the state of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for January 21st, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor. Mr. Gavin would like me to address bond.
Go ahead.
Thank you, Your Honor. So Mr. Gavin indicates to me that his previous failure to appear, he had attempted to be present on Zoom, but didn't hear that his name was called. He does tell me that he would have stable housing, thing with a friend in Detroit. We would have no objection to a home confinement tether. Additionally, Mr. Gavin has let me know that he has 2 jobs that he would be working if he's released, one at Motor Casino, one at McDonald's. Notes, he does tell me his life is significantly more stable than when he failed to appear.
But he failed to appear in 2024.
Correct, Your Honor.
And this is 2026.
It is, Your Honor.
Okay. So what was he doing for now approaching 2 years?
I was working, like, after they issued the bench warrant, I didn't know how to go about that. And so I started working at McDonald's right after. And
okay, so how'd you end up back in custody?
When I when we was driving, like like we was driving and he
Yeah,
got
whenever
pulled.
a story starts that way, it's not gonna be good. Go ahead.
No, he got pulled over because they was doing like 90 and he didn't have his license and his car insurance was suspended. And I was going to get him. And when I pulled in, they was letting him go and then they asked for my ID. And when I gave them my ID and they said I had an arrest warrant. And
That's how you gotta take it in. So if that hadn't occurred, we still wouldn't be seeing you. Yeah, there really isn't a need to answer that, but you wouldn't have come in on your own because you said you didn't know how to, even though you had attorneys. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Thank you.
Court calls the case, people versus Jessica, is it Brasgala?
Brian Bowling on behalf of Ms. Brasgala, who should be present on Zoom, Judge.
Brasgala?
You need to unmute, ma'am.
She's Simpson.
Yeah, that is her, Judge.
Your name?
Jessica Brascella.
Okay.
Your Honor, I'm asking for an adjournment for Ms. Brasgala to pick up and review discovery from my office. It's
To
been
pick it up
prepared.
and review.
Yes.
Probable cause conference, January 29, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case, people versus Joseph Griffin.
Mr. Griffin, who is approaching.
Your name, sir?
Joseph Griffin, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter. We don't have any media in this case.
Pardon?
We're adjourning this matter. Our office has yet to receive the media in Mr. Griffin's case.
Discovery or?
Yeah, the discovery.
And Your Honor, for what's worth, I checked, we do have a disc as well as some video online. We just need to create the media notice and get that over to defense counsel, so it should be pretty short.
Okay. Is there anything else holding him besides these two cases, or? That was a question.
Oh, to me?
Is he being held on anything else? Because that's gonna.
On his other cases, he's has an order for release to treatment, Your Honor.
Okay.
Judge, I am seeing that those located as out of county holds from Van Buren, Wayne to Canton, 2 of those are bond denied.
Got it. Okay. So. Well, let me do this. Let me put these over to the 29th, 2026, a little bit further than I would, but he really wouldn't be going anywhere at 9 a.m. And his bond in these matters then will continue. Okay.
Thank you, Your Honor.
Thank you. I don't have green sheet, but I imagine he doesn't care. Yoo-hoo. Are we gonna get green sheets
Oh, yes,
like today?
yes.
Did you already have them? No, don't, you're, okay. She at least told the truth. Court calls the case, people versus John Brooks.
Hannah Mackey on behalf of Mr. Brooks. Mr. Brooks. Who is approaching? Please state your name.
John Brooks.
Thank you.
Your Honor, requesting to adjourn this matter to continue negotiations. And I have the green sheet for that one.
Exciting to see that. Probable cause conference will be adjourned January 29, 2026, 9 a.m. Bond continues.
Thank you.
Thank you.
I'll be in contact with your mom.
Court calls the cases of the people versus Carlos Hicks.
Sherilyn Foster Tucker on behalf of Carlos Hicks on cases 1294 and 2223.
On the other case.
The Larson, there should be a substitution on file. Okay. I don't know.
Yeah, you guys are on this other case.
Anyway, I can on behalf of Mr. Hicks.
Your name, sir?
How you doing, Joe? My name is Carlos Hicks.
Thank you, sir.
Well,
Short Gain, Senior Assistant Public Defender, representing Mr. Hicks as well.
All right, what are we doing?
Your Honor, we did just receive this case. I've spoken with Mr. Cook. I know that there is some video discovery that he indicates he can get to us in the next couple of days. Mr. Hicks does want his cases set for exam.
Okay. But you haven't seen the video nor reviewed it.
Not yet.
So then, what do you want? And he would understand that if it doesn't get over there, that's not going to be the basis for an adjournment. You
That is
understand that, Mr. Hicks? Okay.
yes.
And I would, so that you know, for consideration, adjourn it 1 week and then set it after you get a chance to look at it and talk with him about it. So that's also an option for you.
Did you want?
Ms. Gaines, on his other matter, what did you guys want to do on that?
Your Honor, I believe it was previously set for a preliminary exam, but I did think
It
we
wasn't?
had withdrawn from that case as well, so I'm just going to.
That his. Let's see. And then he. Did he not appear? Yes. Okay, I see. So back in December of 25, he didn't appear. Got a bench warrant. Who was that set? Okay.
This matter was not on our docket originally, so I have also not had a chance to speak to Mr. Hicks about that past history, but I did speak to Mr. Cook and
Right,
when it was
and
brought
so that I'm clear,
fellow counsel.
so that I'm clear, you were appointed on the matter that he bench warranted on.
On one of them. I think there were two cases set for exam and I was on one. The public defender was on the other. And then,
Well, okay, right, okay, so on 1294, that was the one he bench warranted on,
yes,
you were appointed.
yes,
And you're also just now appointed on 2223.
yes, Your Honor. Mr. Bernstein was.
Right, you're off, okay. And so you want those two set, and is it on 2223 that you don't have the discovery?
That is correct.
Okay, and Ms. Gaines, on his other case, does the PD believe they have a conflict? I mean,
No, Your Honor, as I'm looking at this next piece, that we withdrew from 3 of his cases, and I think. that
and
this is
3,
one
you
of-
withdrew from 3?
Yes, and I think this may be the one that we kept. So as I'm looking at it, I think that's where, but I did not see these case numbers on the docket. So if I could have a moment to ask Mr. Hicks if he would still like to have this preliminary exam, we can go ahead and set it because it had previously been set.
Okay, and here's the other thing. And my next date is what? The 3rd?
Yes.
Okay, so just so also you understand, his case has to come back to me. So it's not going to be set on the 20th. It's going to be set in any event on February 3rd. I think it's my next date.
So it's not me set on the 20th. Do you want to adjourn PCC?
I mean, I'll set them all for that date, although the other one wasn't really before me, but to keep them all together, if that's what you guys want to do.
I don't.
Either way, you're exam.
Suppose if I don't. Happened, but don't want your data. Are you saying?
You guys might want to mute.
I'm living in the ozone. I'm living in the ozone, so I'm trying to get home quick so my bed won't be in jeopardy.
Oh, are those Mackie screen sheets? Is that what they are? While we had that break. Is that what those are? Oh, okay, great. I'll sign it.
Your Honor,
Where's she going?
she's speaking to someone who's,
To who? What? She's, oh. You know, nobody else would get away with this except Miss Gaines. Just walking away. You know, if it had been anybody else, I would have yelled.
I'm so sorry, Your Honor.
No, you don't have to apologize. What are we doing?
Your Honor, I was just confirming, Mr. Hicks was indicating to us that he is a resident at Ozone House, and the Ozone staff is here present. And I was just confirming that they were here present. And we are requesting that while we are going to be making a bond argument so that he would be able to return to Ozone House and be required to follow whatever conditions that they have, as well as to come back to court. And he has drunk driving school tomorrow. I mean, truck driving school tomorrow. Let me just say, let me just say.
They try to get me back in jail.
This is the day that I'm going downhill, right?
She try to get me back in jail.
No, sir, no, sir. Mr. Hicks would never even think.
Hey, I don't drink, sir. I don't
Yeah.
drink.
See, that's all.
I'm really trying to do good, sir.
Yeah, apparently you're going to school for that. So, do the people have a position on bond? I mean,
I just have concerns given the previous failure to appear in the nature of the charges rather than.
And I'll be on tether, so.
Hold on. All right.
and Your Honor, I will indicate for the newest case, I did speak to Mr. Hicks. He has no reason to be at that resident. I think he doesn't live near that residence anymore, so he would understand that he's not to go to that residence for the newest case.
Right. Okay, I get that, but why didn't you show up? I mean, the problem I have is him not showing up for the preliminary exam. I mean, because all the witnesses, everybody's here, and then he doesn't show up. How did he come back into custody?
So if I may start, Your Honor, he is indicating that at the time of the preliminary examination, he was homeless at that time, so his situation is substantially different by working with Ozone House and having a place to stay. Is that correct, sir?
Yes, and they gonna make
Okay,
sure
so I get that part, maybe.
show up to court.
So the other problem that I'm having though is how did he come back into custody? Was he picked up, did the new case,
That is
is
my,
it the new case that he came into contact with police and then that's how we got him back on the warrant?
that is my understanding.
Otherwise, we wouldn't see him.
He does indicate that he tried to contact the court, but there was, I think it was about 4 days.
He's got attorneys all over the place.
Yeah,
I mean, he had you guys.
I had a
And
Friday, sir. I broke my shoulder, dislocated my shoulder, so I was in the hospital. So I never had a chance to call him. So my plan was to call that Monday, but then unfortunately, I got wrapped up in another case. So I was trying to come call, man. Please just give me this. So I won't.
Well, no, see, that's my problem. My problem is you don't appear, and it's one thing, I guess, if you don't appear at a PCC, although I don't like that either, but your case is set for exam, you don't appear.
I give
Then
you
the
my
only,
word.
hold on, then the only way that you get back here is that you have police contact, pick up another case that they arrest you on that warrant. And so now you're held on more cases than when you didn't show up.
Yeah, I give you my word, sir, that I won't. I make sure
You gave me your word the last time. That didn't work.
Hey.
No, it didn't work.
It's the last
You
time.
didn't show up and then you picked up
I
a new
did,
case.
I did try to show up to court, but I just went to the wrong day because I had a lot of court dates. And now I'm in the
Okay, well,
old
that's not a
company.
good thing to
They
tell
gonna
me.
help me make sure I show up to the court. So they gonna make sure you drive me, take me to the court, so I make sure I show up to court. And she actually here today. So
No, I know they're here and they're good people. The problem is you have to be cooperative with everybody on this.
yes.
And you haven't been cooperative with the court.
Yeah, I'll take accountability and I apologize. As a man, I apologize.
Young man, I appreciate what you're telling me. But I don't see how in good faith I can let you go.
Please.
When, thank you for the please, but I'm gonna still tell you, in good faith, I can't do that. I would consider some written motion before the court so that everything can be considered if that's what you want to do. But I can't on the facts of what I see right now do that. I mean, and young man, so that you understand, there was a gentleman this morning, same thing. If you're out, if you're out and you're out on bond, then you don't appear for your proceedings and we don't hear from you because everybody has an attorney. And your attorney's not contacted, you're not doing anything to get back, but the only way that you come back before me is you're picked up on something else. I'm not letting you back out again, absent extraordinary circumstance. Okay?
I understand.
So this one has to be set before me. My next date is the 3rd. And because the preliminary examination that was originally set was before me, preliminary examination in all of these matters will be set February 3rd, 2026, 9 a.m. All of these will be set before me. At this time, his bond will continue. If between now and then you wish to file something, you know how to get to my staff and we can try to set something if the time permits. All right? Thank you. Yeah. I'm gonna be an issue.
Yeah.
Court does call the case, People versus Bernard Brock.
Anna Mackey on behalf of Mr. Brock, who is approaching. Please state your name.
Bernard Brock. Thank you.
Your Honor, requesting to adjourn this matter. I haven't been able to get in touch with Mr. Brock to go over the media. Is there not a green sheet?
What?
Do you have a green sheet or no?
Nope.
There'll be one
This
soon.
seems to be something consistent with you today, Miss May. I don't know. I'm not blaming you. Well, I am.
So we're requesting to adjourn this matter.
No matter January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
You're welcome. We'll await the green sheet. Court does call the cases of the People versus John Hart. 3 cases.
Assistant Public Defender Davi Lebo for Mr. Hart, who stands to my right, and we do have an agreement whereby he'll be waiving. We do have an agreement he'll be waiving his exam.
On all of these cases?
Yes, Your Honor, if I could place the agreement on the record, please.
Go ahead.
Thank you. In the 25F55814 matter, the agreement will be that there be an offer at Circuit Court for a plea to count 1 with a dismissal of counts 2 and 3. In the 5854 matter, there is an agreement to a dismissal of count 1 upon a plea to count 2. And in the 1168 matter, there is an agreement to dismiss that case in its entirety upon pleas to the other 2 matters. And I have the waiver.
Mr. Hart, you understand that you're waiving your right to preliminary examination in these 3 cases?
Yes, Your Honor, I do.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, sir, I do. I do. Yes.
For the
One
record,
other thing, I want to thank you for giving me the opportunity to do that. Because
I'm sorry?
I want to thank you for giving me the opportunity to do that because you've listened to me instead of just rushing me along. The whole time I've come in front of you, every time, you've listened to me and I appreciate that. Thank you. And I'm going to Don Farms now because of you. Transitional. You wanted to send me to Hope, Mercy, whatever, but Don Farms is local and I've been there before 5 years ago and they're great. They're great. I appreciate you.
Well, thank you, sir, for saying that. Then that, I'm not sure what to say, but that means a great deal.
How about Go Blue? Huh?
No, that doesn't, that
Go
really
green?
can't. That's really hard for me to come out of.
I
my
know,
mouth.
I know. Thank you, though.
But I can say go Terps.
For real.
But, all right.
Have a good rest of the day. Thanks.
Well, hold on.
Not done
Got it. We still got more to do here. So,
Okay.
preliminary examination having been waived, defendant is bound over in the case ending in 1168 on the single count. In that case, in the case ending in 4545, he's bound over on counts 1 and 2. And on the other matter, he's bound over on count 1 with counts 2 and 3 following.
Your Honor, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set January 20th, 2026, 1:30 before Judge Conklin. Bond in all of these matters will.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir, and
I
good luck to
appreciate
you. All right. No, I did. I don't know what I did here. I know he does, but he called him first, didn't he? Court recalls case, People versus Bobby Tennyson.
David I. Goldstein appearing on behalf of the defendant. Your Honor, maybe Mr. Cook and I approach briefly.
Briefly.
Your Honor, in this matter, we have discovery. We are prepared to go. I believe the date we've picked for a prelim is the 24th of March.
Preliminary examination in this matter, and people would have their witnesses available the 24th of March. Preliminary examination will be set March 24th, 2026, 9 a.m. That is before me.
Thank you, Your Honor.
Thank you, Bond. Continue. Thank you. Court does call the case, People versus Devon Brown.
Assistant Public Defender Davi Leba on behalf of Mr. Brown, who I believe is on Zoom.
Ron Brown. Patrick.
Well, Your Honor, I did speak to Mr. Brown yesterday, and so I do not have any information as to why he is not here today.
What'd you say? Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety.
Thank you.
That warrant will issue immediately. Let's call the case of the People versus Jermaine Johnson.
Assistant Public Defender Kelsey Regiles with and on behalf of Jermaine Johnson, please state your name.
Ryan Johnson.
Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he is going to be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentencing judge waiver is not checked, but that was reviewed with him.
Oh, I'm sorry. You understand you wouldn't be sentenced in front of Judge Simpson? You-
Yes, yes.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self be God.
Yes, I do.
State your name, please.
Jermaine Johnson.
All right. Sir, it is this court's understanding that you are going to be, well, hold on a second. Yeah, there's two cases, and I'm sorry, I didn't go through the other one. In the other matter, that being the case ending in 5805, he's going to be pleading to use of cocaine. That's a count 3, and counts 1 and 2 would be dismissed, and the sentencing judge waiver would also apply to that one. You understand that, sir?
Yes, I do.
That's Christian. All right. You've been sworn. Sir, I do, on the one case, court believes you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I understand, yes.
And on the other matter that you're going to plead to the charge of use of cocaine, that's also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, I do.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentencing these matters before Judge Valvo, or her successor, which we kind of know now, but I'm not sure the dockets will stay that way, but you understand that, sir?
Yes, sir.
All right. Understanding that, you still wish to plead guilty to these charges?
Yes, I do.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed or had cause to be signed an advice of rights form on your behalf. Is that correct? You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I understand, yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Voluntarily.
Of your own free will?
Sir.
And because you believe that you're guilty of this?
Yes.
Yeah. On the date, starting with the attempted resisting and obstructing on the date of November 24th, 2025, at the location of Las Vegas Drive near Palomar Drive in the city of Ypsilanti, or city of Ann Arbor, Washtenaw County, state of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
I rode off on my bike.
You what?
Rode off, tried to get away.
Did they give you an order to stop?
Oh, they told me to stop.
They told you to stop. You said, I'm not stopping, and just kept going.
I was thinking about Thanksgiving.
You were thinking about what?
I was trying to make it to Thanksgiving. I promise.
What day was Thanksgiving?
Was it 20? It was the 24th. Trying to make it to.
So 3 days before you were trying to make it to Thanksgiving, where were you going?
I was trying to make it home.
Okay. No.
Myself in.
Oh, gotcha. I see what you're saying. That didn't work out, did it?
No, it didn't.
Yeah, it didn't. Okay. And you knew that they had given you a lawful command at that point, and you disobeyed it.
Yes.
All right. The other case. These would be uniform, there wouldn't be a problem. I'm not gonna worry about it, we'll just find it in. Seriously, people. On the date of June 4th, 2025, at the Packard Road near Platte Road, city of Ann Arbor, Washtenaw County, state of Michigan, did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not, first of all, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty In each of these cases, 2 count 3, counts 1 and 2, I think the both matters, are dismissed. Precepts investigation and report is ordered at 15th District Court. Probation sentencing will be
Third at 9 a.m.
February 3rd, 2026, 9 a.m. And it's before Judge Valvo in each of these cases. On will continue. He has I did, so that you're aware, I don't know if it was sent to you. They requested that he be released to treatment. I approved that on his cases. So he might go to treatment. That was something through the sheriff's department that they sent us.
Would Your Honor consider, in light of the plea, a personal bond today and then allowing him to, of his own volition, seek treatment?
You really want to go back through the warrants where we had to find him?
Oh, you're not gonna have to find me.
Well,
We do have his current address. We know where he would be located.
I should have just let it go. What I was trying to tell you is I've signed an order to release to treatment.
Oh, yeah, that's fine too.
And that was sent through the jail process as opposed to, and I've approved his release to treatment. If you'd like him released on a PR bond, you can take that up with Judge Valvo's successor or whoever's handling it. I'm not going to change it at this point.
I understand.
All right?
Thank you, Your Honor.
Thank you, sir. Good luck to you.
You have to fill out his packet.
Okay.
Court does call the case of the people versus John Brown.
Brian Bowling on behalf of Mr. Brown. State your name for the record, please.
John Brown, how you doing, Your Honor?
I'm doing okay. I may be.
Judge,
Go ahead.
for purposes of the probable cause conference, I'm asking for an adjournment so that we can review the video from the incident with Mr. Brown.
You have his violation?
I do. I'm aware of it. Mr. Brown and I have spoken about it, Your Honor.
Okay.
Your Honor.
Want to deal with that? I'll give you the adjournment.
Yeah. Ultimately, Your Honor, Mr. Brown, I would advise you against saying anything.
Well, I was going to speak on the violation. So
I was going to speak on the violation, but you're welcome to do it if you'd like to.
honestly, Your Honor, it was on a violation. It was a misunderstanding. When I went over there to drop, and then she called me back for a phone interview. I asked her what was the next, and she said that would be up to the judge. So 3 days later, I spoke to Alexis, my old lawyer, while I was at work, and
Your Honor, may I say something on Mr. Brown's behalf with respect to the violation? Judge, he would admit to missing those tests on November 13th and December 18th. However, he did report concurrent and tested on November 3rd. He's currently
and was positive for THC. You got a medical marijuana card?
He does not, Judge. He indicates to me that he's on probation with Judge Slay. To my understanding, that's going very well. He did surrender himself on this matter to address this case. He does want to comply with this court's bond conditions. He wants to test as ordered.
Then why didn't he go?
Well, he did go originally, Your Honor, but
I went and he's positive for a drug he cannot by court order. So then we don't see him again.
Well, like I said, he is on probation. There is an order with that court and that status to test. I do believe Mr. Brown, and we spoke last night after receiving this report, where there was a misunderstanding with his discussion with Ms. Dozier that the testing that he was doing on probation would be satisfactory for the purposes of bond. That turns out that was his understanding. That's not accurate, Judge.
Is that where the case? Why did he go on the 3rd?
Because that was the initial intake. That was the initial test. So if the court would allow him to go over to community corrections now, he could get testing established and he would continue testing. I cleared it up with Mr. Brown when I talked to him last night and today. I
still doesn't have a card. Is marijuana going to show up in your system?
It will, Judge.
a little bit will.
A little bit?
Yeah, I don't know how the levels go.
Just a little bit of weed.
Cause I don't know how the levels go on New Year's Eve. I don't drink, so I did. I did eat an edible.
Smoking what you got.
I mean, I'm not gonna lie to you. I mean,
no, I don't want you to lie to me. I'm just saying you're on bond.
Yeah. And I didn't even, like, I was, up until I spoke to him yesterday, I was unaware that it was even illegal to smoke marijuana because it's legal. So it was just, it really was a misunderstanding, Your Honor. I'm asking you not to lock me up for it. Right now, I'm working, I got a full-time job. I really can't afford to lose no days right now.
Should have gotten testing. What I'll do is I'll only set it out 1 week to the 15th. Let you guys try to figure that out and maybe give me the testing that he's doing on his other matter in circuit court. But at this time, the defendant's bound to revoke.
Thank you, Judge.
Court does call the case People versus Sandra Law. She's coming. Law, do they have? I don't even know what file it goes in, right? Your name, ma'am?
Sandra Law.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Law. State your name.
Sandra Law.
Sorry, here's a scanner for you.
Stephanie Kane on behalf of Ms. Law.
Really? Why are you late?
I know reason. I'm sorry, Your Honor.
All right.
Sorry. We're going to ask for an adjournment on this matter, Your Honor, while we negotiate in this case. I would like to address bond.
Again?
Yes, Your
Is there
Honor.
going to be anything different than I heard the last two times
She just-
that I denied her bond?
Well, Your Honor, she's been in for almost 70 days now, not quite. I think it was like 67 days when I checked. And they're not releasing her to treatment. There's nothing keeping her but your case. My client absolutely does. I'm sorry, I'm a little bit out of breath.
Said
now.
that, the only, like I'm to blame.
No, yeah, I mean, no.
Are you, no, okay, all right, okay.
Judge Washington gave.
No, Cannon, you're doing really well. Go right ahead.
No, because Judge
Blame
Washington
me.
gave her a PR bond. So the only case that doesn't have a PR bond with release to the house is yours, is what I meant by that, Your Honor. Yours turning red? Because I feel like I'm turning red. And so, Your Honor, again, my client, she does want to go to treatment. We're requesting that she goes to treatment. If you tether her to her home, she will go to outpatient treatment. We've done the
What
process
would
here.
change my decision from the last two times that you've argued this? Just give me those.
Well, Your Honor, I believe that the court wants her to be in treatment as well because this case is a drug-based case. She had been sober for a full year. She had been doing her drops, her testing in Judge Washington's, which is why Judge Washington let her go. She came back, she had COVID, she got really, really sick. And then her grandmother passed away, and she acknowledges that in that moment, she made a bad decision, one that she regrets deeply. One that she regrets very, very much so. And she just was
I've
asking
seen
for
the
an
movie
opportunity to come out.
Groundhog Day.
I have, Your Honor.
Yeah.
I really have. It's a
And
great
it's like
movie.
it just repeats and repeats and like.
My client asked me to ask you to
know.
please reconsider, Your
And
Honor.
I want her in treatment. I really don't want to hold her.
I understand.
But, and that's why I said, treatment, great. But do I trust and will I release her on a straight PR? At this point, I will not.
And Your Honor, thank you.
Can I speak, Your Honor, for a minute, please? I wrote you a letter and I signed up for schooling to start January 5th for psychology. And I do have a job and they only hold it for me till February. And I do have a house, which you know the situation, and we have a court date tomorrow with you with the Sturman Serenity and the Thomas Berry case. And I please ask you, because Judge Washington did want me to go to treatment, and I've been in her court with her since 2023. And I promise you, I will get into intensive outpatient treatment. I promise you, you will have no dirty drops. I will drop 2-3 times a week for you. I don't want to lose my schooling, my house, my job. I've worked so hard for 2 years to get sober. and worked with Judge Washington, I promise you, she's put me on house arrest tether, not a GPS. So I can only go to work for my 3 months of probation. I promise you, I will do your court with flying colors if you please PR upon me to go home so I don't lose everything I worked so hard for. I wrote you a letter, Your Honor, pleading and begging you to please. I don't want to lose everything. I don't want to have a gap and go backwards in life. I've been an addict for 15 years, and it took me 2 years to get where I am today for one relapse over a death in the family that I've beat myself up over. I went to my doctor. I've cried to him. He had put me on a cocaine blocker called Topamax. So if I ever came across a situation like this again, where I've had a damper in life, I would have the blocker to stop me from using. It was a one-time relapse. And like Miss Washington said, the old Sandra would have tried to beat the test, beat the system, just not dropped and missed the test. And she was proud of me that I didn't try to beat the system and took responsibility of my dirty drop. And I did. I didn't try to do anything to beat it. I didn't try to, I just, please, I beg you, you'll not have to ever put me in jail for a dirty drop again. I promise you that on everything I love. I don't want to lose what I've worked so hard for. It's been a struggle for me since 2023, working with her to get this far. And, I was already on the tether, set to go to treatment the day I had court with her. And that's what stopped me from going, because she was going to put me into a long-term treatment. But then when she realized and evaluated the case, she said, no, I'm not going to do that to you, Ms. Law, because she knows the struggle I had and how long it took me and how hard I worked to get where I was. And I can't say anything but to please give me that chance. I've never been in front of you, and I promise you, you'll never have to ever worry about me being in front of you for a dirty drop again. That's all I can say, Your Honor, please.
I'll adjourn this matter to January 22nd, 2026, 9 a.m.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Case People versus Amaya Campbell.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Campbell, Your Honor.
Oh, there she is.
She's here.
Hi, good morning, Your Honor.
I'm doing well. Your name?
Amaya Campbell.
Thank you. You're requesting an adjournment on this.
Yes, Your Honor, there's some video we need to get a look at. I thank Mr. Childers for requesting it.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
For cause case of the people versus, versus Melvin Lilly.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Lilly, just to let you know. Mr. Lilly, will you state your name for the record?
Melvin Lilly.
Thank you. I'm asking for an adjournment. I did reach out to the prosecutor's office for consideration for a reduction. They're reaching out to the officers.
Probable cause conference, then January 22nd, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. For cause case of the people versus Gerald Casanova.
Assistant Public Defender Chelsea Reveals on behalf of Gerald Casanova. I haven't had contact.
Haven't had. Casanova. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue immediately. For cause case of the people versus Chalice McLaughlin.
Hannah Mackey on behalf of Mr. Chalice McLaughlin.
All right, what are we doing?
Your Honor, we're waiving. I believe there was a traditional waiver done already, but
Okay, record should reflect you had a bench conference in this case. And we're going to adjourn this matter out just 1 week to try to determine what happened prior to the waiver of jurisdiction in this case, because that will dictate what will happen to you. So I'm adjourning this to the 15th, 2026, 9 a.m. Bond will continue. Thank you.
Thank you.
Court calls case, People versus Wesley Brand.
And then on behalf of people.
Wesley Brand,
It's not in, Washtenaw County Jail.
not on yet. He's in custody, but I'll pass that.
It's gonna be just a couple minutes on Brand. I'm starting to make my way down there. If you can just give me a couple.
Okay, all right. We'll wait. Turn on the camera. We'll call you back. Court does call the case, People versus Donovan Smith.
Okay, well, right here, I'm people on behalf of Donovan Smith. Donovan, would you state your name for the record? Would you just state your name for the record?
Donovan Smith.
Thank you.
Judge, this is a situation we're at. I was just appointed on this case. This is his second case. His first case about a month ago, we bound over to circuit court. To Judge Kuhnke, there was an argument of what had happened. Long story short, Judge Kuhnke yesterday ordered that the case be remanded back down to district court for a preliminary exam. And
on what theory?
Well, Judge, this case and the case that the original case both had the same offense dates, were hours apart. It was our argument that they should have been bound over. We should have known them together for what that's worth. And so long story short, I got a note from Judge Kuhnke's office that they were remanding the case back for the 15th. So I was going to ask for a 1-week adjournment and get these matters.
Had the other case already heard an exam?
No, we waived the exam, Judge, on the condition that the bond was lowered, which it was by you, from 50,000 to 10%. And then once we got up to circuit court, we found out about this case, which was the exact same day, only hours apart. And our argument was that we should have known about both cases.
Okay.
So all I'm asking is, Judge, if I know my client wants to have an exam in this matter, I don't have the police report, but that's fine. If he wants to set an exam, we can set an exam. But I was told by the Judge Kuhnke's court, the case would be set for the 15th. I don't know if that's true or not. I guess what I'm asking for, Judge, is I know this is a very impatient man, set matters for the a week from today.
May I speak?
Go ahead.
First, I don't know if you remember me or not, but I've been in here.
I remember everybody.
I adjourned like 6 times.
No, I
And
remember.
then my lawyer made a deal with the prosecutor. They'll 10% my bond and they can't add no new charges if
I remember. Well, I don't know that no new charges were. I remember
That's what he
it
told me
was
that
just listen.
Okay.
I'm telling you what I remember specifically about it, because it's unusual for me to even agree to it, was that you were going to waive up and I reduced your bond. All right. That I do recall.
That case was a discharge of a building, so it was our impression that
Right.
they weren't going to add any firearm charges to that, any additional charges. I did not know about a second case where he was allegedly caught in a car with a gun. So now this charge is CCW. I can understand his frustration, but there are 2 different cases at the same exact day.
Yeah.
I never got arrested with a gun. They never.
Sir, I don't want to talk about the facts of it. I'm just procedurally trying to figure out why in the heck we're where we are. The case waived up, right?
Correct.
I reduced his bond. Did he get out? Did you get out?
He tried, that very day, they charged him the second day. He never got a chance. He was arraigned a $25,000 bond on this case, which prevented his release on the first case. He never made it out, Judge. He was about ready to.
So there was an agreement that he'd waive up. I reduced the bond. They then charge a new case and he's held.
Correct.
That's beautiful.
So what we were asking today on this case, if it would be $25,000, 10%, I don't believe the prosecutor has an objection to that. hopefully both matters can be heard next week and this young man. can
Well,
be-
I don't even know, here's the problem. And I don't have a problem with that, Mr. Kilowald. The problem that I have is something's coming back from circuit court. It's supposedly set for the 15th. I don't know that. And usually, if something is gonna be set on this docket, we get a call. If somebody tells us, because we'll give them the date. And so what I'm a little bit worried about is I'm gonna adjourn this young man's case out next week, and I still don't have that other case.
I think I can't say for sure, but it sounds to me like the circuit court case, circuit court.
I don't know why that's coming back to us. I don't get that. And I'm not saying that anything you're telling me is not what you know. I don't know why it's coming back, and you're telling me there's this case coming back. He's got this case. I remember what I did when I released him on the other case. And now he's back in, and you want me to give a date that I don't know is gonna be able to go for. I mean, none of this is making much sense to me.
I think this young man thought that there would be no new charges.
Well, whether or not there are new charges or not, I don't know that is necessarily my issue right now. My issue right now is I'm trying to get his case heard. And this case that's in front of me right now, I can't even get that heard because now you're telling me there's this other mythical case coming back to, I don't know. And it's on the same date. Do we have anything?
1 week. No. You don't understand what I'm saying.
No, here's the thing. If I adjourn it out, well, you guys have your conversation. I'll just wait.
Judge, I'm sorry. I understand his frustration, but I don't have.
Well, yeah, I understand his frustration too, because he waived up. I reduced his bond, new charges come. He then gets he then can't go. And then when the case goes up, regardless of what his understanding was and what that was, now all of a sudden it's gonna come back. Meanwhile, while all that's happening, I'm in custody. So, gee, I don't know why he's frustrated. Because as you can tell, I'm not. Okay, but here's what I'm gonna do, okay? You may not like the answer that I get, but at least what I'm gonna do is I'm gonna get an answer. So we know what to do, okay? Because I don't wanna set it for next week. And next thing I know, that case coming from circuit is 2 weeks out, because then I got to bring him back again. That doesn't even make any sense to me. So say nothing.
Judge.
Say nothing.
As far as bond?
Say nothing.
You're very considerate, Judge. Judge, I think, would you?
What?
What's the probable cause for this case?
Fine.
Please ask that.
Here's what I'm gonna do. I'm gonna pass the matter, take him back. I'm gonna call down, or have my staff call down. We're gonna figure out where this man's case is at, where everything is, and try to get it all where it's supposed to be.
All right, thank you.
And nobody may like the decision I make in the end, but at least we'll know what's happening, because right now, we don't even know what's happening. You understand me?
Yeah.
Say nothing. Take him back. Court calls the case, People versus Donovan Smith. No, that was the same case. Why are you doing it? Just. Is this the one? It is. Court calls the case, People versus Wesley Brand. Why'd you take those other ones?
And Maggie on behalf of Mr. Brand.
Mr. Brand, can you state your name for me?
Wesley Brand.
Thank you. You're requesting an adjournment.
I am, Your Honor.
You got to get the discovery. Probable cause conference will be adjourned to January 22nd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Mark Copeland.
Hannah Mackey on behalf of Mr. Copeland. Who is, Mr. Copeland?
What are you doing to Lebo look? Are they here or not? You know what the Lebo look is?
Pardon?
You know what the Lebo look is?
The what look?
Lebo look.
No.
Lebo gets up here all the time. I call the case. He doesn't know if his client's here, but he looks at the door expecting some miracle. So I expect that's what you're doing.
How did I get involved?
You're the cause of it.
I tried to get a hold of Mr. Copeland. His phone number was invalid and his email was also invalid. We're respectfully requesting to adjourn this matter so I could attempt to get a hold of him.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case People versus Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. And all discovery is complete as far as we are aware.
Would the people have their witnesses available the 20th? Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour.
May I just bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Responsible.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer. There was a struggle then for that hammer, and during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that she sustained, I'm going to object at this point to any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are 2 weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that. Even while I'll factor that in, I still don't think bond would be appropriate, or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Good. Guys want to walk around? Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen.
Who is that? Who was that?
All right, I'm gonna just step off. If she brings him in, just throw her in the box over here or cuff her, put her wherever. Lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking
back?
to my mom lawyer and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm gonna take a brief recess and then I'll bring her back out. We'll deal with it.
All right. There's an in custody, Don Trellis. Okay, thank you.
Court calls the case of the People versus Earl Covington.
Brought out assistant prosecuting attorney on behalf of the people.
Assistant Public Defender Davey Lebo on behalf of Mr. Covington. Don't think it's a Lebo look if he's walking in.
Come on.
Could you state your name, sir?
Earl Covington. Thank you, sir.
And you're going to be requesting an adjournment today in order to continue some discussions as well as get some additional information.
Probable cause conference, I'll set it for January 29, 2026, 9 a.m. Or as your invite indicates.
Thank you.
And will continue. Thank you, sir. He's a Jim. Court does call the case People versus Dontrell Smith.
Dontrell Smith. Your Honor, Mr. Killwall had to go back to his office real quick so he could cut that.
This is not Mr. Cole.
Oh, I'm sorry.
I'm ready to go. Mr. Smith is in custody.
Pardon? I don't have it.
Brian Bowling on behalf of Mr. Smith, he's in
Are
custody.
they not respond? Yeah. He's,
They're not responding.
they don't have some,
Dontrell Smith is in Zoom. They have turned off their.
I know. But now the camera's on.
You ready for Smith, Your Honor?
Yes, sir. Yes, sir.
All right, we'll get him.
Hey Smith, come on, you ready?
Guys, call the case of the People versus Dontrell Smith.
Brian Bowling on behalf of Mr. Smith. Mr. Smith, can you state your name, please, sir?
Can you tell us your name, Mr. Smith?
Smith.
All right, thank you.
I'm asking for an exam, Judge. I believe all discovery to be complete.
People have their witnesses available the 20th. Preliminary examination will be set in person, January 20th. Is that right?
Yes.
2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Brandon Myers.
Glenn appearing on behalf of Mr. Myers. Can you please state your name for the record?
Brandon Myers. Thank you, sir. All right, what are we doing?
We would like to request an adjournment and when appropriate, I'd like to address bond.
So do I have a green sheet? No.
Oh, yes. I will.
Probable cause conference in these matters will be adjourned to January 22nd, 2025, 9 a.m. All right. Yes.
Okay. Your Honor, we are requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house. I'm sorry, to his mother's
My
house.
mother's in the courtroom too.
She has a lot of health needs and she has,
Is this the same motion that I already denied? Oh, yes, you did. The motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that enough? She's in the courtroom?
yeah. He wants me to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
You went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008 and you said you did know my mother. She's right there, the light skinned lady.
The light-skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay.
Her right there.
Hello. Okay.
Okay. Your Honor, we believe tethering him to the house would keep him from interacting with the complaining witness. And he is well aware of the PPO and in this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
What?
No, I don't give you no hard time either. I do what you do.
People can give me a hard time. When you go back, you can ask that young lady. Is there a response from the people?
Yeah, since this motion was already brought about a month ago, we asked the court to be denying it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees. Also showing up at the victim's church, creating where he also.
That's a lie.
Safety of public is necessary. And that bond should be continued.
I ain't threatening nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, then maybe the parties can stipulate to something, but I'm not at this point going to change the bond or the court's decision. The motion for bond reduction is denied.
Thank you, Your Honor.
Court calls the cases of the People versus Bernard Lee Fonville. 6 cases.
Mr. Bonville, will you state your name for the record?
We found him.
Thank you.
Thank you.
Your Honor, we're asking for an adjournment to review discovery with Mr. Bonville.
Is it extensive or is it?
No, there's just 6 files to review, so.
Yeah,
just
that's what.
A couple weeks. I provided him a copy of the discovery today, so.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Good night. Take care.
Court calls case People versus Johnny Charles Payne.
Michael Gaddy, Assistant Public Defender. Payne is approaching
Your name, sir?
Johnny Payne, sorry.
Thank you.
Yes, Your Honor, I've had a chance to speak with Mr. Payne and with Mr. Cook. Your Honor, I'd ask Mr. Payne has a parole hold I need to investigate. We were going to set this date for exam, but I'd ask the court to adjourn it so that I can continue trying to reach his parole officer.
The 22nd or 29th?
The 29th would be good, Judge.
Probable cause conference January 29th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls the case of the People versus Carlton Cross.
Thank you.
Assistant Public Defender Davi Leba on behalf of Mr. Cross.
Hello. Hello, what's your name?
My name is Carlton Dion Croft.
Thank you. You're
Thank you,
asking for
sir.
an adjournment for additional discussion.
I am, Your Honor. Thank
Probable
you.
cause conference, January 29, 2026, 9 a.m. bond. Continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge. Thank you.
False case, people versus Adam Perella.
Assistant Public Defender Davi Leba on behalf of Mr. Perala. Could you state your name?
Adam David Perella.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 20th. Preliminary examination in person, January 20th, 2026. Sorry. 9 a.m. It's gonna take me a minute before Judge Fresh Hour.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case of people versus. Zakara, Daphne. Bursiaga.
I expected this to be called when you took that pause, Judge. So,
Yeah.
Brian Bowling on behalf of Ms. Daphne Bursiaga, Your Honor, can you state your name for the record?
Zakara Daphne Bursiaga.
Exactly what I said. I'm pretty proud of me. Go ahead.
Your Honor, we're asking for an adjournment for ongoing plea discussions in this matter.
Okay. What? Council Roach. No, this is. Let's do February 5th, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue. Court calls case of the people versus Jack Saunders.
And on behalf of people.
Stephanie Cannon on behalf of Mr. Saunders, who's approaching. Mr. Saunders, could you please state your name for the record?
Jack Lee Saunders.
Your Honor, we are asking for a 2-week adjournment in this case for plea negotiation purposes.
Without objection, January 22nd, 2026, 9 a.m. Bond continue.
And Your Honor, there is a violation.
Is there?
It's my understanding.
Our relation was brought at trying to go to.
Yes, basically, yes. And there's, well, it says a lot of stuff.
Here's a bond violation, no bond.
Yes, Your Honor. So we are going to ask for a hearing as to the violation. My client had double pneumonia, and so for a chunk of this, he was just in the hospital. And so we got to get.
Have proof of that?
We're getting release of information for University of Michigan and for Trinity. So when I
For the
spoke with
22nd at 3 p.m.
122, Your
And
Honor.
I'll set a hearing on bond violations at that same time.
Thank you, Your Honor. Perfect.
At this point, his bond will continue. Thank you. Court calls case people versus Juwan Daniels.
And Mackie on behalf of Mr. Daniels.
Your name, sir? Juwan Daniels. Thank you.
Your Honor, requesting to adjourn this matter.
What is it with you and the green sheets? What is the issue? You know the routine.
It's been a while, I think. It's been a whole year since I last seen you.
No, that was last year. That was not a whole year. That was good though. She was probable cause conference. will be adjourned January 29th, 2026, 9 a.m. Bond continuing.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Kirby Snyder.
Alex Chamalowski, people.
Chief.
Veronica Glenn on behalf of Ms. Snyder. Please state your name for the record.
Kirby
please.
Snyder.
Your Honor, we would like to request a 1-week adjournment.
Why 1 week?
We need time to get discovery.
Is there anything else holding her? Because I'd give her 2 weeks, but 1 week is really for emerging circumstances. Nothing else is holding. We don't know why you asked for 1 week. Cannon sent you up here to say, do 1 week because you know that'll irritate him.
We need discovery. That's all I have.
That's all you have?
All I
They
have.
just sent you out there, threw you to the wolves. They need to treat you better. I'll adjourn it 1 week because you asked. There might be a reason. Oh, no. January 15th, 2026, 9 a.m. And because you at least have your green sheet, Ms. Mackey.
Thank you.
I don't even know what cases, if she do it.
One's right before this one.
Yeah, I know, but I don't even know if we have the file. Court does call the case, people versus David Davenport.
Good morning, Your Honor. People.
Glenn on behalf of Mr. Davenport, can you please state your name for the record, please?
David Davenport.
Thank you.
Your Honor, we would like to set this for a preliminary exam.
All right. Discovery is complete.
Yes.
Oh,
Your Honor, I don't believe discovery is complete. I discussed earlier, originally we are going to set, for example, and I thought we discussed a second time, we were going to adjourn for that discovery. It's not that.
Your Honor, Stephanie Cannon on behalf of Mr.
so
Davenport.
you didn't give the information to Ms. Glenn?
I
Is
did-
that no?
I did
That's
not,
a
Your
yes or no response. Don't
I-
worry about it. You're not in trouble.
That is correct. Your
What?
Honor.
That's a yes or no, right?
Yes, it is.
You did not give the information to Ms. Glenn, and so she took the instructions that she had them,
Yes.
correct?
That is correct.
Okay, now that we know that you have fallen down on the job and that there is needing to be an adjournment, you can sit down.
Yes, no.
No,
still
I
can't
don't need
sit
to hear
down.
from you. Sit down.
Still can't.
Sit down. I don't need to hear from you. I'm only gonna hear from Ms. Glenn. Don't try to whisper in her ear what to do. I'm gonna adjourn your case out till they get all the discovery.
Okay, Your Honor, we would like to request an adjournment. We also would like to make a request to allow him to return home.
Probable cause conference will be adjourned. Well, where's home?
Where's home, Mr. Davenport?
Ann Arbor,
Ann Arbor?
3310 Fernwood Avenue.
Oh, he wants to return to his home address.
Yes.
It's not like, you made it sound like he lived in another state. I'm like, what state is he? Where's he? Okay.
And Your Honor, people were looking for the victim that they are no longer living there, so I would have no objection to allowing him to return home and lifting the no-go too.
Motion for modification of bond in terms of the no-go to. Granted, because of Ms. Glenn's wonderful argument that was made.
Thank you.
So you may return, the no-go to will be lifted on that. And I will adjourn, given that, I'll adjourn this matter out January 29th, 2026, 9 a.m. As your invite indicates, bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you for your patience with Ms. Cannon. Court calls the case, People versus Alicia Wittenberg.
Assistant Public Defender Jay Bellinger on behalf of Ms. Wittenberg, who approaches Your Honor. Can you state your name for the record, please?
Alicia Wittenberg.
In your honor, 28 days ago, I submitted a 14B recovery court referral.
Yeah.
I have only today, after emailing them 7 or 8 times, have I heard back from them. So unfortunately, she hasn't even been processed yet. When I spoke with Mr. Reyes from that court, he advised that he didn't even know that she was in custody. So that as well as the fact that you submitted it, you signed an order for her release to treatment. I've tried to be in contact with Sarah Stewart, who is handling her case. I submitted that on day 1 as well when she went into custody. Sarah Stewart still hasn't gotten back to me. It's been 7 or 8 times that I've contacted her. Ms. Wittenberg has been in for the last 28 days. As I stated, she was in on a bond violation. Your Honor, at this point, I do need to adjourn her case for the processing of the 14B recovery court referral. However, I am going to again renew my request for her release. She is working in intensive outpatient therapy with U of M. She has submitted that to the court prior as evidence. I want her to be able to be processed in one way, shape, or form as soon as possible through no fault of her own, as she's just sat in jail.
Yeah, I know. And my concern is I realize there are delays trying to get people into treatment. I'm just, there are 2 avenues here where something should have happened and nothing has.
Yes.
That concerns me. And I would prefer, quite frankly, if there's going to be a process where she can get into a recovery court, that's going to be the best shot for her, right?
Certainly.
So
Mr. Reyes did advise, because he didn't know that she was out of custody, that he could, if she were to get out of custody, he could give her a call and set up an appointment by Friday.
In custody?
If she's in custody, he said he would need to set up an appointment with her that they still haven't unfortunately done.
Turn her out to the 22nd, 2026 at 9. At this point, I'm going to continue her bond. I will consider something different if she's not, if we're in the same boat on the 22nd. I will certainly look at some way to do this differently so that she can get assessed. She's just waiting. I don't think she should have to. I get if there's not placement. I get if decisions aren't made, but at least it's a preliminary part of assessing. We need to be able to get that done.
Yeah, I know that she stands to lose a lot, including her job, Your Honor, and I know that she wanted to speak to that aspect of it. I don't know. I know you've already made your ruling, Your Honor, but
what do you want to tell me, Liam?
The only thing I was going to say is I do have good private insurance, and that's, I have called myself and was told that I could get in under my own private insurance, but unfortunately, because I'm in here, I can't. If I was out, I'm just feeling like it could be faster than waiting.
Here's what I'll do. I'm going to set it for the 15th. Somebody needs to do that. Mr. Manager, if what she's indicating, get me some information that says that she can't do it while she's in custody, and then I'll reconsider everything, but I'll just put it out 1 week for him to get that. We'll take a look at it. Fair enough?
Yes, thank you.
You're welcome. Thank you. Court calls case People versus David DeLucia.
Assistant Public Defender Chelsea Virgils with and on behalf of David DeLucia. Please state your name.
David Mark DeLucia.
Right, I've up every close.
Your Honor, he will waive his right to a preliminary exam.
Is that correct, sir?
Yes.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to you'll proceed to circuit court for further resolution.
I understand. Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over circuit court on both counts.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for March 4th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Let's call the case, People versus Antonio Williams.
Good morning, Your Honor. Raymond Cook for the people.
Answer. Thank you. You're requesting an adjournment?
Oh, yeah, well, Your Honor, this is a time for a competency review.
Yes.
I don't think we're near the 15-month period. I think it's a 10-year max on this matter. We did contact the forensic center. They said they met with Mr. Williams on the 18th of December, but they haven't completed the report yet.
Got it.
I wasn't able to get a date as to when it would be done.
All right, why don't I do this? Because we can always move up to date. Why don't I comp review? I'll adjourn it out to, I don't want to go that far, but I'm going to go February 26th. If we get a report, we can certainly move his case up.
Thank you, Your Honor.
9 a.m. Bond continued. Thank you.
Your Honor.
Yeah. Is he talking?
Yes, he was. I think he had a question.
Did you want to say something to me, Mr. Williams?
Yes.
What do you want to tell me, sir?
I need a way to make a phone call. They won't let me make a phone call without money on.
To tell what?
They won't let me make a phone call without money on.
Oh, okay. And
Nobody knows I'm in.
so there's somebody that you want to call to let them know that you're in?
Yes.
Okay, so here's
I've
what,
been here 6-7 months and nobody knows.
okay, and you know the phone numbers of the people?
No, I don't.
Okay,
I
so,
know what. It's the Elk Swim Club Card Club.
okay, so here's what I'm gonna tell you to do, Mr. Williams. I think what you should do is give a list to your attorneys as to who you want to have contacted to let them know that you're in, and let your attorneys follow through on that for you, okay?
Will they do it?
Will they do it? Is that what you're asking?
Yes.
I would suspect that they would. If they believe that it's in
Okay.
your interest, they will do their best.
They haven't in the past.
Your Honor, this is a matter that Mr. Williams and I did speak about yesterday.
Oh, you've already talked about it.
Yes.
Okay, all right. Then let them take care of it. And then if they don't, then you can let me know in February, okay?
Or I could bond out of jail if I could get to this.
To these people you might be able to bond out,
Yeah, I would.
then certainly your attorneys are gonna do everything they possibly can. I can tell you that for sure. Okay?
Thank you.
Thank you. Court calls the case, People versus Robert Dolan.
Andrew Children, on behalf of the people.
Just bear with that.
He says that much of that. Mr. Lebo, where is he? This is you, we have you on this case.
Oh, is this Mr. Dolan?
No, it is.
Apologies, Your Honor, I didn't quite hear the case name.
All right.
Assistant Public Defender Davy Lebo on behalf of Mr. Dolan. Mr. Dolan, can you tell the court your name?
Thank you. sir.
And Your Honor, we did receive some media on this case. I'm going to need some time to review, so I'd ask for perhaps a 2-week adjournment.
Pardon?
We have some media that would need some time to review, so I'd ask for a couple weeks adjournment, please.
January 29th, 2026, 9 a.m. or as your invite indicates. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Terrence Ginyard.
Assistant Public Defender Jay Dolan, on behalf of Mr. Ginyard. Your Honor, I'm just gonna hold the door.
Okay.
Mr. Ginyard, can you please state your name for the record?
Terrence Michael D. Allen Ginyard.
And Your Honor, we're here for PCC today as well as the community corrections warrant. And I just want to first start off with the PCC. I am still working as fast as possible. I've talked to Mr. Cook about this case. He was just assigned to it after Mr. Overwater. So I am working to get a resolution as quick as possible on this. So I would be asking for adjournment for 2 weeks.
I'll adjourn the probable cause conference to 22nd,
As
2025, 9 a.m.
26, Your
The
Honor.
bond violation.
As to the bond violation, Your Honor, I did send into the court some a urinalysis as well as a lab that was taken for blood that goes back 2 weeks in response to the allegations that he was testing positive.
Where do you have that? Where do I get the indication that this test goes back 2 weeks?
May I approach, Your Honor? Okay, all right.
What I'm going to do, record to reflect a bench conference in this case. Right now, he has a no bond bench warrant because of 2 tests. I've received other information that quite frankly isn't inconsistent with the testing because it could be low. His testing could indicate low or no use within the past 2 weeks. I will adjourn this matter out, set it to the 22nd. I'll adjourn it out 1 week to the 15th, 2026 at 9 a.m. At this point, however, the defendant's bond is revoked. I will indicate that based upon the request from counsel. Once I can get a straight story on this, then I will consider at that time his release on a scram tether as opposed to the sober. But at this time, defendant.
Right.
Letting you know that.
Your Honor, can I speak 1 second? I'll make it quick. So on here, I don't think what you did see, I know it says that the CDT result 1.4 is consistent with low or no alcohol. But at the top, it says my current result and flag is 1.0, which means it's under the 1.4, which could be low or none. So my test is 1.0. Okay.
He did read it.
All right. That's all, sir. That's all I want.
And I also know, so that the record
Yes.
is clear, that on the sober link, on 2 occasions, you tested positive. And on the retest, continued to test positive.
Understood. That's why I pay for this test though.
I understand why you did it.
Yes.
But I'm saying, I'm telling you how this looks.
Understood.
All right?
Yep.
And the only reason I may consider release is because of the advocacy of your counsel. Because normally I wouldn't consider release. Normally what I would do is I just revoke your bond and you're gonna sit there.
Yes, sir.
But I'll bring you back in a week and we'll look at it again.
Yes, sir.
Thank you.
All right. Thank you.
Thank you, Your Honor.
I got it.
Let them go back, okay?
You say.
I put it out, instead of 2 weeks, I put it out what? To the 15th. Yeah, it's a Thursday, the 15th.
At what time?
Well, I set it all at 9. It'll go into a block. You can talk to his attorney. They'll figure it out. Okay? You're welcome. Court calls the case People versus Devon Reed.
Brian Bowling on behalf of Mr. Reed, Your Honor.
Devon Reed.
Judge, I'm asking for an adjournment if I could. So that I think we've got the issue with respect to the video discovery ironed out with Mr. Chavalowski. So I just
You have it ironed out.
I believe.
Get it? Okay.
Yes.
All right. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Thank you, sir. Court calls the Yeah, refusing. Court calls the case People versus Stephen Giffen. Gavon.
People.
Given, yes. He's refusing to come up.
He refused to speak with me as well, Your Honor. I do have a green sheet for his behalf, on his behalf. The prosecutor and I have discussed this case, not to a point of resolution, but we are trying to figure out the next steps.
This is set for confidential review.
Your Honor, it's my understanding that he has as of yet not spoken with them. He's refusing
right.
to speak with anyone.
All right, then I'll adjourn it out. See what you guys can come up with. They're out February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
I like it.
Court does call the case of the People versus, this is Donovan. Too bad. Oh, there he is. Donovan Smith. Well, they got.
Good afternoon, Robert J. Kill on behalf of Mr. Donovan Smith. Donovan, would you state your name for the record?
Donovan Smith.
Okay. So here's what I'm gonna do, best I can try to come up with. Is he gonna want exams on these? Is that the deal? Or what?
Oh, especially the CCW.
All right, that's
Yeah.
fine.
Yes.
Fine. So I've got the paperwork. What I did is I took the one that they sent back. You got the CCW here. Are both going to be requested for exam? So what I did is that rather than wait till next week, I got the paperwork. We're going to deal with it. What we're going to do today.
Okay.
Okay. So I'm just not going to wait. So I'm asking, what do you want to do on both of these cases?
You want to go to have exams on these?
Is it both in one?
Huh?
Is it?
Let me just say this also. Because the one that was a waiver was assigned to me, it has to come back before me.
That's fine.
So if you set, oh, thank you. But if it's set, Norma, my next date would be February 3rd, but given all of the circumstances it is, and I'm not sure why things are happening the way that they're happening. I'll give you a special date as soon as I possibly can to put it before me.
That's fine.
Okay, so do you want exams on these?
If not, what's the other option?
Well, we can either wait back up to circuit court. Okay, well, then we need exams, Judge.
You want to?
Yes, my client would like to have exam.
And I think it's more important. Mr. Smith, you understand what I'm trying to do, right? Okay. So normally if I were setting today, it would be the 20th, but I'm not on the 20th. What do we? On the 20th, I can, if the other courtrooms are empty. I can do that. Okay. All right. So I'll set it as though you're asked. So I'm taking a week's time. Okay, best I can do. So I will set the preliminary examination in person. I'll set it for January 20th, 2026. You want me to do 1? Yeah, let me put it at 1 p.m.
Judge, not to cause any problems, I have a full docket with Judge Kunke that day. Is there any chance?
Well, she could have kept this one and you could have been on it. I'm sorry.
Is there any chance we could do that
Go ahead, what?
Is there any chance we could do it in the morning of the 20th?
No, because what's happening, the other judges are in my courtroom.
Okay.
And that's the best I can, are you gonna be there all day on the 20th?
I have 4 cases, yeah. sentencings and show causes.
Give me another date, but it's gonna have to be before the 20th. I'm not gonna have it.
Okay, so we could do the 14th, Wednesday, the 14th.
At 3?
Oh,
Yes.
I like to go home.
it's,
You want for the 20th, yes, sir? Or you-
Right,
So it would have to be Wednesday, the 14th at 3 p.m.
is the next time I have.
that's what my client wants, Judge. I'll know this afternoon if I'm going to trial on the 12th, but let's just schedule it for the 14th.
All right, we'll set it for, then I'll set it for the 14th. Pardon? I have prelims on the 13th? Well, what the hell? I mean, heck. Wait, what did you- My apologies for that. Why didn't you just tell me? I thought I did. I'll just set it on my prelim docket. January 13th, 2026. That'll be at 9 a.m. What were you guys doing?
Judge, just for the record, I'm pretty sure if my trial goes, I'll have to.
What were you guys, what? I know, so. What?
We can skip if I have to.
What were they doing? I told you, I didn't want him waiting. I have the 13th, no.
The 14th, still before the 20th.
I had to do this the last time. They stop talking. 9 a.m. That's before me. So we're gonna get you in before even the time that was set for the case coming back. Now, the issue regarding bond, and I'm trying to, I need to figure this out. At the time, on the case that went up and has now come back, I gave him a personal.
No, you gave 10% bond. He had
10%. Did he
50,000
post
cash
that?
surety. He was going to post it that day, but that day also the new case came in. That case has a $25,000 cash bond. So right now he has a $50,000, 10%, 25,000 cash. We were asking if the court would consider 10% on.
So, right, I got you. So the one he was gonna post, he is still in a position to post that one, right? Is that, am I right?
50,000, yeah.
The 50, you could still post.
10,000. 10%.
At the time that the agreement was made, him waiving and reducing his bond, were the people aware of that other case?
Judge, I can tell you that I authorized the charge on the 19th to put it into play. I don't, we didn't get the money until the 29th.
30.
No. Here's what I'm asking. When,
Judge, for what?
I hate the days I'm talking French because nobody's understanding me. Listen, on the, when he waived up, what date did he waive up?
23rd.
23rd of
December.
And that's when the agreement was made to reduce his bond.
Yes.
Correct.
So then this other case is out there. And so based upon those dates, the people were aware of that other case when the agreement was made to reduce his bond.
Yes.
Good, that's all I need to know. So on his new case, the carrying a concealed weapon, he's gonna post on the other case. I'm gonna set that for preliminary examination. I'm just going through, making sure my paperwork's clear. 13th, 2026, 9 a.m. before me on that case. On the court's own motion, that way I'm doing it because I think it's fair. I'm going to reduce his bond to a $25,000 personal recognizance bond.
It means that's a PR bond, but if you don't show up to court, you'll report 25,000.
So if he can post the other one, he can post the other one, and we're going to be back right where we're supposedly supposed to be. Except that you're not in circuit court, you're before me.
25 grand. Thank you very much for your consideration.
Got that? Okay, we'll see you on the 13th. And if you get out, don't do anything stupid.
I'm not.
You hear me?
Yeah, I don't even live in Ipsy.
Well, you
I'm
going to do
gonna come
something
back
stupid
down.
someplace else?
No.
I just said, don't do anything stupid. I don't care where you are. Got it?
Yeah.
Thank you. Am I?
On the right, I think we're both in the same individual.
They are. Court recalls the case People versus Tanisha Aiken.
Good afternoon again, Your Honor. People.
So someone with an apple hearing on behalf of Ms. Akins, is Washtenaw. Ms. Akins, will you state your name for the record?
Tanisha Akins.
She's waving.
Yes, Judge, she is waiving. There is an agreement to HIDA on both files. Additionally, the 25 F2 1212 file, there is a misdemeanor offer if she is able to pay a portion of the restitution, but we'll do all that in circuit court. But the people are not objecting to HIDA.
All right. Ma'am, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts in the two cases.
Your Honor, we acknowledge receipt of the information. My client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Both cases, pretrial will be set.
March 2nd at 1:30 for Judge Mood.
March 2nd, 2026, 1:30 before Judge Hamoud. Yeah. And will continue.
Okay, thank you, Judge.
Thank you. Court does call the case, People versus Randall Laird.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Randall Laird, it's a PD case.
This case was called.
I think it's Miss Apple.
Yes, sir. Can you hear me?
Yes, I got you, Mr. Laird. Thank you, sir. I got you. I'm looking for your attorney.
So this is Ms. Defender again, an apple hearing on behalf of Mr. Laird.
All right, what are we doing on this case?
Your Honor, we are asking for an adjournment. I have a sheet here.
We are missing the discovery, all the discovery on this case. I did reach out to the Attorney General regarding that.
All right. Any objection to the adjournment?
No, Your Honor.
All right. Probable cause conference will be adjourned January 29th, 2026, 9 a.m. as your invite indicates. Bond will continue. All right, thank you. Thank you, Mr. Laird.
Thank you, sir.
That is for the AG or no?
One more.
She has the next case also. Okay, she does. Court does call the case, People versus Tiffany Peters.
Good afternoon, Your Honor. Assistant Attorney
Attorney
General.
General.
Thank you, Your
Take
Honor.
care. Court calls the case, People versus Maya Hughes.
Ms. Hughes, would you state your name for record?
would you state your name for record?
Maya Hughes.
Whatever other device you have.
Whatever
turn it
other
off.
device you have, turn it off.
What are we
Judge,
doing?
I just got. I'm asking for adjournment.
I'm asking for.
All right, go ahead. What?
I'm asking to adjourn this matter. I just got the discovery. I did forward it to Ms. Hughes, but I haven't had the pleasure of speaking to her about it. Is it possible to get the same day, the 29th? You being the considerate judge you are.
Didn't think that earlier.
I can't do the 29th. I have another court date the 29th.
At my client's pleasure, I will ask for another date.
Pardon?
I will ask for another date then, Judge.
February 5th, 2026, 9 a.m.
Thank you, Judge. Ms. Hughes will talk.
Court calls case people versus Yakub Farah.
On behalf of Mr. Barr, who's working out.
Well, my name is Jacob Farr.
Yeah, we can do it.
Okay, can you sign? Your Honor, I did discuss an offer that was extended for a waiver in this matter. Mr. Farah did wish to waive his right to preliminary exam, proceed to circuit court. He'll be entering a plea under HIDA and a dismissal of count 2, plead to count 1.
Yes, sir. Here we go. Well, this Caro's wrong. I got account. I have account 2. Anyway, I got it. All right, so you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination, having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. My client, wait for reading. My client will stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
Second at 1:30 before Judge Hamud.
March 2nd, 2026, 1:30 before Judge Hamud.
Thank you.
Thank you, Your
Thank
Honor.
you. Bond will continue. One's gotta go. Court calls the case People versus Jacob Pike.
Good afternoon, Your Honor. Randy Cook.
Assistant Public Defender Hannah Appleton, on behalf of Mr. Fike, is approaching.
Your name?
Jacob Pike.
Take your hands out of your pockets. Yes, sir. What are we doing?
Your Honor, I believe that we will need an adjournment for Mr. Fike.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Fike. Mr. Fike, I'm sorry. Yeah, yes, I'd ask for the court for a brief adjournment in this matter. I need to go over some things with
I need
Mr.
a
Fike.
green sheet, January
Yes.
29th, 2026, 9 a.m. Bond continued. Thank you. Right. Court calls case People State of Michigan versus Elder Vasquez Sanchez.
Your Honor.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Vasquez Sanchez in his absence today. If counsel and I could very briefly approach, Your Honor.
If you're going to discuss the reason he's not here, I understand.
Okay, thank you, Judge.
So what do you wish for me to do? I can adjourn it out.
Give me a raise and dismissal. No, I think that's
Just adjourn it
appropriate.
out.
Figure it out.
And
Yeah.
You guys can, okay. Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bound continued.
Your Honor, both Mr. Vincent and myself are in a trial and a death case on Third Circuit that day. If we could do
So
any
there's
day.
some other judge that's going to be painfully,
Yeah,
they're going to have. the
for
paper-
days at a time too. I mean, if you want to send flowers, I'll tell
Both of
you.
you.
And Your Honor, if I may, we may not even need to come back on that.
Right.
Day, so I think we can set it for that day and counsel. will not-
That's fine as well. We can always stick if we have. to.
Okay, that took a lot longer. All right.
As always, Judge. Thank you.
Court calls the case People versus Jacob Halfacre.
Okay, well.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. Halfacre, who's now standing to my right. Mr. Halfacre, if you could state your name for the record, please.
Jacob Halfacre.
Thank you.
And Your Honor, we're in active negotiations with Mr. Chebolowski. We've had some productive discussions and feel like there is a reason to request that the court adjourn for further negotiations.
29th be enough time for it.
I would think so.
Yes. Probable cause conference, January 29th, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you, Mr.
Thank you, Chief. Thank you very much, Your Honor.
Thank you. Court calls the case, People versus Brittany Fisher.
Veronica Glenn on behalf of Ms. Fisher, she should be on Zoom.
Ms. Fisher? Oh, there she is. State your name.
Yes, I'm Brittany Fisher.
Thank you.
Your
All right.
Honor, we're requesting a adjournment on this matter.
Green sheet.
Thank you.
Probable cause conference in this case, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Ashley Floyd.
Good afternoon, Your Honor.
Assistant Public Defender Chelsea Virgils with and on behalf of Ashley Floyd, who appears via Zoom. Please unmute and state your name.
State your name.
Ashley Floyd.
Thank you.
Yes,
Your Honor,
sir.
I have a green sheet. We are asking to adjourn to receive media and continue our discussion.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the People versus Alan Fife.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Fife, who's approaching judge.
Your name, sir?
Alan Fife.
All right. You're requesting an adjournment in this one.
Yes, Your Honor. I believe Mr. Fife may be a good candidate for the Specialty Veterans Court.
Probable cause conference, February 5th, 2026, 9 a.m. Continue.
Thank you.
Thank you. Thank you, sir.
Thank you, Honor.
Court calls the case, People versus Aaron Grable.
Assistant Public Defender Jim Bellinger on behalf of Mr. Grable, who should be appearing via Zoom, Your Honor.
Grable? Oh, there he is. State your name.
Aaron Grable.
Thank you.
Your Honor, we are just asking for a brief adjournment. I anticipate that this is going to end in a nully, so we just need a couple weeks to figure the rest of that out.
January 29th, 2026, 9 a.m. Bond continue.
Thank you.
All right. Thank you, Mr. Grable.
Thank you.
Court calls case, People versus Jesslyn Gray.
Andrew Thomas appearing on behalf of the people.
Assistant Public Defender Donovan Lee on behalf of Ms. Gray, who appears via Zoom. Ms. Gray, could you please state your name, ma'am?
Jesslyn Gray.
Thank you.
And Your Honor, we'd like to please set this matter for preliminary examination. Discovery is complete.
People have their witnesses available the 20th.
That's fine.
Preliminary examination in person, January 20th, 2026, 9 a.m. That is in person before Judge Moore. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Edward Gross.
Good afternoon, Your Honor.
Chelsea. Mr. Gross, can you?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Gross.
Mr. Gross, can you state your name, please, sir?
Hi, Edward Gross.
All right, thank you.
How are you doing, sir?
Huh?
How are you doing?
I'm doing great, thank you.
Good, good.
Okay. Your Honor, we're asking for an adjournment so that we can have some further discussions with our client.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue. Thank you, Mr. Gross.
Thank you, sir.
Calls case, People versus Suzette Hampton.
Yeah, Assistant Public Defender on behalf of Ms. Hampton, Your Honor.
Hello, state your name.
Suzette Hampton.
Thank you. What are we doing?
Your Honor, we'd ask the court to set a preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 20th.
Your best.
Preliminary examination in this matter will be set in person. January 20th, 2020, 9 a.m. For Judge Fresh Hour. Right here. Bond continue. Thank you. Court calls the case, People versus Dustin Hufford.
Assistant Public Defender Chelsea Ridgeels with and on behalf of Dustin Hufford, please state your name.
Dustin Hubbard.
Your Honor, I have a green sheet for this one as well. We're just asking to adjourn so I can discuss things a bit more with Mr. Hufford.
January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
I'll give you a call.
Court calls case, People versus Roger Jacobs.
Assistant Public Defender Jay Ballinger on behalf of Mr. Jacobs who approaches. Mr. Jacobs,
Good morning. State your name.
Roger Jacobs.
what's that look for?
Huh?
What's that look for?
What look?
You're giving a look.
Because I was going to tell him my package was late.
Glad to be here, that's why.
He's never heard that.
Oh, because you had to be here. Sorry, we inconvenienced a bunch of people, right? Okay.
Your Honor, my client was just made an offer. He would like some time to take it, to consider it. So we're just asking for 2 weeks.
That's fine. January 29th, 2026, 9 a.m. Whereas the invite indicates bond will continue. All right, thank you, sir.
Thank you, sir.
Thank you, Your
Have a
Honor.
good day now.
Have a good day and drive safe.
Sure.
I want one of those blue trucks. I don't have to put anything in it. I'm just gonna drive it around. Makes people happy. Court calls the case of People versus Adonis Johnson.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Johnson, who's approaching judge.
Your name?
Adonis Johnson.
All right.
Your Honor, I've had a chance to go over this matter with the prosecutor, with Mr. Johnson. We got the court for a very brief adjournment to continue discussing this matter. There's also some body cam I'd like to review it.
Oh, there's body cam. That's what.
Or if I wrote it, it might be Bubba. Okay.
Yeah, I don't know what. I was trying to figure out what that was, but I got it now. All right. Probable cause conference in this case. I'll adjourn this one to February 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Court calls case People versus Anthony Johnson.
Good afternoon, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson, who should be appearing via Zoom.
Mr. Johnson, Anthony Johnson, need to unmute, turn your camera on. State your name, sir.
Anthony Johnson.
Thank you.
Your Honor, I did submit a referral to our mitigation team to have a report completed. So if we could have a few weeks,
Okay.
I'd appreciate that.
Probable cause conference, February 5th, 2026, 9 a.m. Bonds will continue.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Court calls case People versus Ethan Jordan.
Good afternoon, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Mr. Jordan who approaches, Your Honor. And can you state your name?
Jordan.
And Your Honor, Mr. Jordan, we did stip to adjourn this off the record so that Mr. Jordan could hire U of M legal services for this matter. He has been able to do that. They were shut down during the holidays. They just need to do a substitution of attorney. So I'm just asking for 2 weeks so that they can get on this case.
Probable cause conference, 22nd. January 22nd, 2026, 9 a.m. bond continued.
We set at 9 a.m. right now, but your attorney should be able to call the court date the real time. Okay,
All right.
take care of the buck.
Court does call the case of People versus Kalisha Journey. Virginia's, where is she?
Hannah Apple appearing on behalf of.
We're gonna cuff Virgil's to the podium.
What was that? Oh. Took a minute to process what you said. That's okay. Miss Journey, can you state your name for the record?
Journey.
Yeah, so her last name on the file needs to be amended and on the complaint. And it's actually just her last name. Because we have it on the complaint as Journey. There should be an A after the E and before the Y. Is that right, ma'am?
Yes, sir.
All right. So is there any objection to the amendment of the complaint regarding her last name?
No, Your Honor.
Do that right now. Ugh, I can find it.
Thank you.
You're welcome. What are we doing on this case?
I have a green sheet, Your Honor. We're asking to adjourn so that Ms. Journey can review the media discovery.
For her media discovery?
Have it, she wants
You
to do
haven't.
it.
Got it. All right, then I will adjourn this one to the 29th of January. 2026, 9 a.m. Bond will continue. All
Thank
right.
you, Your Honor.
Thank you, ma'am.
Thank you.
Still trying to find my complaint. Court calls the case People versus Vincent Julian.
Good afternoon, Your Honor.
Stephanie Can on behalf of Mr. Julian.
Are you here? I don't have him on.
Your Honor, he would not be present by Zoom, at least not at this time. It is my belief and understanding that Mr. Julian is currently being housed at the McLean Jail in Minnesota with anticipated transport to a prison in Minnesota. So he would not be present by Zoom today.
Not said that way.
Oh,
Minnesota.
Minnesota.
Say it right.
So we are going to ask for an adjournment of this case to see if he can be with it here.
Probable cause conference, February 12th, 2026, night. Continue. I'll give you the adjournment rather than issue a bench. We'll start.
Thank you, Your Honor.
Calls the case People versus Lamine Kaba.
Defender Don Lebo for Mr. Kaba, who appeared via Zoom. Mr. Kaba, could you state your name, sir?
Lamine Kaba.
Thank you.
And Your Honor, we're here for a competency hearing today. I'm not in receipt of a report from the forensic center. Senator,
I don't have a report either.
and Mr. Kaba has had his appointment.
He has?
Yes,
Okay. Then
and I do have a green sheet.
I'll adjourn this out.
Oh, I'm sorry, that was the wrong sheet.
Where I'm kind of putting these. I'll adjourn it out to February 26th. We may move the date up if we get the report before then.
Thank you, Your Honor.
February 26, 2026, 9 a.m. Bond will. Thank you, Mr. Kaba.
Thank you.
Let's call the case of the People versus Mohammed Kaba.
Stephanie Mr. Pan, on behalf of Mr. Cabo, who is approaching. Mr. Cabo, could you please state your name for the record?
Mohammed Kabla.
Thank you.
Your Honor, we're asking for an adjournment of this matter. Just
sure.
if we can get some sort of negotiations going on.
January 29th, 2026, 9 a.m. bond continued. Thank you. Cause case of the people versus Tebby and Lewis.
Afternoon, Your Honor.
Yeah, he's just a public defender on behalf of Mr. Lewis who's approaching.
Your name, sir?
Tavian Lewis.
Your Honor, we're asking for an adjournment. There was there's some body cam. There was some problem with the sound. I was able to, troubleshoot my computer and fix it, but not in time for today's hearing.
January 29th, 2026, 9 a.m. bond continued.
Thank you, Judge.
Court calls case people versus Diana Lewis.
And back on behalf of Mrs. Lewis and Zoom. Miss Lewis?
Vivian Lewis. Diana Lewis, excuse me. Diana Lewis. And
Your Honor, I'm asking to adjourn this matter.
okay. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Calls case people versus Tricia Lopez.
Brian Bowling on behalf of Mr. Lopez, or Miss Lopez. excuse me.
Hi,
Speaking
Tricia
of the record.
Lopez.
Thank you.
Your Honor, I'm asking for an adjournment so I can review discovery by myself and with Ms. Lopez.
Probable cause conference, February 5th, 2025, 26, 9 a.m. bond continued.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Tina Mageria.
Brian Bowling on behalf of Ms. Magira.
Mageira.
I like his.
I was wondering whether to make G. Well, anyway, I did.
Tina McGear.
Judge, I'm asking that this matter be set for a preliminary examination. All discovery is complete.
And would the people have their witnesses available the 20th? Preliminary examination in this matter will be set in person January 20th, 2026, 9 a.m. before Judge Breshow. Bond will continue.
Thank you, Judge.
Court calls case of the people versus Khalid Mahmood, excuse me.
Assistant Public Defender Chelsea Ridgel with and on behalf of Khalid Mahmood. Please state your name.
Khalid Mahmood.
Thank you.
I have a green sheet. We are asking to adjourn for media discovery.
Media discovery,
Yes, Your Honor.
29th, January 29th, 2026, 9 a.m. bond continue.
Thank you, sir.
Just in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be a respondent. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes,
Tell me what your thought is on why I did.
because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was too much.
This is my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries. And nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with that, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No,
You think you can conduct yourself?
yeah, yes,
Young lady, I'm gonna give you another chance. If you come back in here and act the way you did, I'm gonna guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you
that way.
were today.
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release you. Let her go.
Thank you.
Thank you. Court is staying in recess, and I guess we'll come back and do our 2 o'clock block and on. Court does call the case People versus Roderick Miller.
Good afternoon, Your Honor.
Roderick Miller.
Thank you, Your Honor. Assistant Public Defender Davi Liba on behalf of Mr. Miller. Mr. Miller, are you present on Zoom? Your Honor, I have not been able to reach Mr. Miller.
Yes, as a violation. Correction.
I have not been able to discuss that with him either, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case of the People versus Amante Moore.
Andrew Childers agreeing on behalf of Assistant Public Defender Jay Bellinger on behalf of Mr. Moore, who approaches. Come on, Joe. And put your hands on your pocket, okay? Say your name for the record.
Amante Moore. Thank you. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle, that being a one-year misdemeanor. Upon a successful plea to that count 2, count 1 would be dismissed. That is the court's entire, there's a sentence agreement of HIDA. You did go through a sentencing judge
Yes, I explained to him that he wouldn't be sentenced in front of you, Your Honor.
because that box is not checked.
I apologize.
Make sure that that's checked on this.
Thank you.
That the people's understanding of the.
It is.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Amante Moore.
Moore, it's this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Farr in the 1482 district.
Yes, Your Honor.
Understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form or had one or caused one to be signed on your behalf?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights. If you are part of a trial, you understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to flee?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
All right, because you believe that you are indeed guilty?
Yes, sir.
October 5th, 2025, at the location of Panama Avenue near Dawn Avenue in Superior Township, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes, sir.
Was there a firearm in that motor? Did you have a firearm in that motor vehicle?
Yes, sir.
Where was it located?
Under my seat.
Okay. And was it loaded?
Yes, sir.
And do you have any authority whatsoever to carry a weapon in that fashion?
No, sir.
All right. Sir, I do have to advise you that between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation and or recommendation. You understand that?
Yes, sir.
Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be January 20th,
Yes.
2026, 10 a.m. before Judge Barr. Will continue.
Thank you very much, Your Honor. Appreciate it.
Court does call the case of the people versus David Najera.
Assistant Public Defender Jay Bellinger on behalf of Mr. Najera, who should be appearing via Zoom. I see him.
Yep, there he is. Sir, state your name.
David Najera.
All right.
Your Honor, we are very close to a resolution here. One of the complaining witnesses was on an extended leave from work due to medical reasons. My understanding is that those conversations are being had, so we should have a resolution by next PCC.
I'll join up February 5th, 2026, 9 a.m. Bond continues.
Thank you very much.
All right, thank you. Thank you, sir.
Your Honor.
Case of the people versus Jared Prince.
Assistant Public Defender Hannah Apple appearing on behalf of the. Yeah.
State your name, sir.
Jared Prince.
All right. I have before me a plea form that indicates the defendant will be pleading guilty to 2 charges. The first is stated count 2 of use of a controlled substance, a 1-year offense, and also attempted possession of a loaded firearm in a motor vehicle, a 1-year offense. That being counts 2 and 3. Upon the successful plea to that charge, count 1 would be dismissed. There is a sentence agreement between the prosecutor and defendant of Haida, and he signed the sentencing judge waiver. That's the court's full understanding of the agreement.
Yes, Your Honor. That's correct.
Is that true on behalf of the people?
That's correct.
All right, very good. May I have him sworn?
Solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Jared Prince.
All right. Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges.
Yes.
First being the stated count 2 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes.
Also, an added count 3 of attempted possession of a loaded firearm in a motor vehicle, which is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture to weapon or device. You understand that, sir? All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you'd be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. You still wish to plead?
Yes, Your Honor.
All right. To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of attempted possession of a loaded firearm in a motor vehicle, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yep.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of November 5th, 2024, at the location of 650 South Forest Street, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes, Your Honor.
Did you have a loaded firearm in that motor vehicle?
Yes, Your Honor.
Where was it located?
Center console.
Do you have any authority whatsoever to carry that weapon in that fashion?
No, Your Honor.
All right. And on that same date and at that same location, did you also have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was cocaine?
Yes, Your Honor.
All right. Sir, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
At 8:30 before Judge Perry.
January 30th, 2026, 8:30 before Judge Perry. Bond will continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Christopher Quinney.
Good afternoon, Your Honor.
Excuse me, Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Quinney, who's, I believe here by Zoom, Judge.
Oh, there he is. Mr. Quinney, state your name, please, sir.
Yes, Christopher Quinney.
All right. You're seeking an adjournment.
Yes, Your Honor. Thank you for allowing Mr. Quinney to participate via Zoom. He is ill today. I'd ask the court to adjourn it briefly so I can discuss this matter further with him.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
All
We'll
right.
be in touch, Mr. Quinney.
Thank you, Mr.
Yeah.
Quinney. Feel better, please.
Welcome, sir. Thank you, Judge.
Court calls the case, people versus Caitlin Quinn.
Assistant Public Defender Davey Leave on behalf of Ms. Quinn. Ms. Quinn, can you tell the court your name?
Caitlin Quinn.
All right. Where are we on this?
Your Honor, we're going to be requesting an adjournment order to review the discovery. I can prepare a green sheet, and I am prepared to address the bond violation.
Yes, go ahead and address
Thank you.
bond.
So with regard to the bond violation, Ms. Quinn indicates to me that since her arraignment, she has not used fentanyl or cocaine. And the fentanyl, she indicates to me, has been sent out for a confirmatory test, and she believes it to be a false positive. With regard to the cocaine.
What, the cocaine?
With regard, no, the fentanyl, Your Honor. With regard to the cocaine.
What about the cocaine? Yeah.
Ms. Quinn indicates to me that she last used cocaine, she believes, on the 17th or on the 16th before she was placed on bond, and that she believes it's residual from her prior use.
Really?
That is what Ms. Quinn has indicated to me, Your Honor.
How much cocaine did she use?
She indicates to me that previously to being put on bond in the States that she was a fairly heavy cocaine user.
Okay.
Yeah.
But how much did she use on this 16th day?
Ms. Quinn?
You know, okay, before you answer, seriously, probably one of the worst things you can do with me is lie to me or have me think you're lying. And I really am not as stupid as I look. So with all of that, go ahead and say what you were going to say.
Your Honor, I used it before I was told that I had to start testing. I'm a single mom and I would not do anything to mess up this violation. I have a slow metabolism, I think, and I promise you I would not do anything to mess this up. I have a lot going on.
You have such a slow metabolism that it would stay in your system 2 to 3 times longer than it would a normal human being?
I thought it was.
Is that what you're telling me?
I thought it was 6 days and I researched it online and it said that it could take up to like, I don't know, like 14 something days. I would never violate this.
And then on top of it, one of my other medications that I use has not been showing up on my drug test.
So what am I supposed to take from that?
Well, I just don't know I don't know why the fentanyl got happened. And so I
You
can,
don't know why the fentanyl happened?
no,
Really?
I'm not just over here doing fentanyl. I contested it, sir, Your Honor. I'm a single mom and my father's, I'm
The
just,
third time, I now understand.
I'm
you're
sorry.
single mom.
Yes. I would not do anything to mess this up, and I really would appreciate a chance to show and prove to you that I am better
Yeah,
than
you
that.
haven't had a clean test since you were arraigned.
I tested today.
You did?
Yes, I did.
Okay.
And I was going to ask, Your Honor, if the court would consider contacting community corrections to determine the results of today's
I
test.
don't know if they've completed the test. I don't know, given these, why would I rush it? Because I don't believe her.
I suppose, Your Honor, I would ask the court to consider giving Ms. Quinn the benefit of the doubt and therefore waiting for the tests to come in.
So I would have to await another dirty test? I already have 3.
I understand where the court's coming from, Your Honor.
Well, here's the benefit of the doubt I'll give. If maybe she has a clean test next week or this week, then I'll consider that in terms of what her bond should be. So I'll adjourn this out only 1 week to the 15th. 9 a.m. But at this point, given what I see here, you want a hearing on that bond violation?
Your Honor, could I confer with my client about that?
Pardon?
Could I confer with my client about that?
Sure.
So we can have a formal hearing to contest the violation. We would have to have expert testimony, and I think in all likelihood it would not wind up being in your favor, so I don't think we should hold it.
What is it?
I think we should just defer that decision until the next test.
Okay.
Your Honor, I'd like to defer that decision until we have today's test results.
Till what?
I would like to defer that decision until we have today's test results.
Oh, okay. So the 15th, 2026, 9 a.m. Defendant's bond at this point, given what I see, I'm revoking the defendant's bond, defendant remanded.
Thank you, Your Honor.
Court calls case of the People versus Lawrence Ransom.
Good afternoon, Your Honor.
Brian Bowling on behalf of Mr. Ransom. Your Honor, I have a green sheet. May I approach?
Yes, you may. Your name, sir?
Lawrence Ransom.
Thank you.
Your Honor, as the green sheet indicates, I'm just seeking an adjournment for additional plea discussions in this matter.
Probable cause conference will be adjourned to January 29, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, sir. Court does call the case of the People versus Rayvon Reed.
Public defender here in Apple, again, on behalf of Mr. Reed, who's approaching now.
Mr. Reed, will you state your name for the record?
Rayvon Reed.
Thank you.
All right.
Your Honor,
There's some video discovered.
Yeah, one body worn camera that we are trying to track down.
Okay. Probable cause conference, February 5th, 2026, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Take your hat off before, thank you. Court calls case, People versus Jacob Sims.
Good afternoon, Your Honor. Robert Elman with it on behalf of Mr. Sims. Can you please state your name for the record?
Jacob Sims.
Your Honor, I've been newly appointed on this matter, so just asking for an adjournment for some time to get discovery and
everything.
Yes.
Probable cause conference, January 29, 2026, 9 a.m.
Thank you.
Bond will continue.
Well, set for the help. See you soon.
Case, People versus Ty Smith.
Good afternoon, Your Honor. Raymond Cook.
Good afternoon again, Your Honor. Robert Elman on behalf of Todd Smith, who should be present over Zoom.
Can you see me?
What's your name?
Tosh, man.
Thank you.
Your Honor, similar to my last case, I was just appointed to this matter and I'd be asking for an adjournment.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Thank you, ma'am. Court calls the case of the people versus Ellen Reinhackle.
Correct. People. Public Defender Jay Valley on behalf of Mr. Ryan Hackle.
Ellen Reinhackle. All right, I have with me a plea sheet that indicates that the defendant will be pleading guilty to the charge of attempted fleeing and eluding fourth degree. That is a misdemeanor punishable by up to 1 year incarceration, a $250 fine plus court cost. Upon his successful plea to that charge, count one would be dismissed, and he has executed the sentencing judgment.
Correct, and that box is checked this time, Your Honor.
Yes, it is. All right. That's the court's full understanding. Is that the people's understanding?
Yes. Our understanding as well, Your Honor.
All right. May I have him?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Yeah, I do. State your name, please.
Alan Reinhackle. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted fleeing and eluding fourth degree. That is a misdemeanor punishable by up to 1 year incarceration, a $250 fine plus court costs. And that? Yes, sir. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Yes. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
This, right?
Yes,
You went over that last time.
Yeah.
Yep.
Any questions regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Sure.
On October 29, 2024, at the location of Tyler Road and McCartney Avenue in Ypsilanti Township, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
And you came into contact somehow or another with police. What happened during that whole thing?
I was coming down McKinley from Grove and Washtenaw County Sheriff got behind me. I knew it was the cops and then I drove away. I didn't stop.
Why were they trying to stop you? Did they tell you?
No. And, this guy behind me and
He got behind you, light
my-
sirens?
yeah, yeah. My plates were not good,
There you go.
expired.
Okay,
you know, like-
and so you knew, take your hands out of your
Oh, sorry.
pockets, and you knew that they were going to
Arrest
pull you over, right? And potentially arrest you.
Yes,
They had lights and sirens on,
yes, yeah.
and rather than pull over, you drove away.
Yes.
And you continued to drive away.
Yes, yeah.
And they had to pursue you in order to ultimately arrest you.
Yes.
So that really didn't work out for me.
No, I turned myself in.
What?
I turned myself in actually, but
It didn't work out for me.
Yeah,
on the
it's-
real-
It did not work out for him.
sorry, I'm a little nervous.
No, so am I. Don't worry about it. All right. Sir, if I accept your plea, right? And between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, nor would the court be bound by any sentence evaluation or recommendation, and you would not be able to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, aware of any other promises, threats, or other inducements that have led to this plea?
No.
No, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 12th at 10 a.m. before Judge Washington.
February 12th, 2026. What time? 10 a.m.?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you very much, Your Honor.
Thank you, sir. Case of the people versus Keith Sanders.
Raymond Cook, the people standing up for AP Childers.
Hannah Mackey for Mr. Akeem. Sanders,
Not here.
I don't think so.
Keith Sanders.
Your Honor, I'm requesting a show cause.
Coming off the bench. Did Gaddy tell you to say that? Did he tell you to say that? Because one of you is getting punished.
For asking for a show cause,
Uh-huh.
advocating for our clients.
You're gonna pay. No, I know it's not her, because
I was gonna say direct for the show cause, Judge.
I will not issue a show cause. I'm gonna issue a bench warrant. Bench warrant will issue in the amount of $10,000 cash surety. Or will issue immediately.
Thank you.
Good job, Gaddy. Training them well. Court calls the case of the people versus Renee Schimmel.
Alex Federowski, the people.
Assistant Public Defender Chelsea Ridgeo Smith, and on behalf of Renee Schmel, please state your name.
Renee Schimmel.
Ma'am.
I have a green sheet, Your Honor. We are asking for an adjournment to discuss a plea agreement and believe there's some restitution at issue.
Got it. I'm trying to figure. Okay. Probable cause conference, February 5th, 2026, 9 a.m. Bond will continue.
February 5th. Thank you.
Thank you, ma'am. Court calls case of the people versus Diana Scott. Did you know you had the case, or did she just give this one to you right now?
No, I knew.
Huh?
I knew.
You knew?
Yes.
Okay.
Veronica Glenn on behalf of Ms. Scott. Well,
Scott, can you state your name, please?
Deanna Scott.
Thank you.
Your Honor, we're requesting an adjournment in this matter.
Of course you are. Do you have a green sheet?
Yes.
You do. So she must have known. Because if it had been canon,
Oh,
no way.
we're requesting adjournment because we want to enter a no contest plea.
Oh, and you have to do paperwork. Okay, gotta get the paperwork in. So then I'll adjourn this matter. It's probable cause to January 22nd, 2026, 9 a.m. Bond at this point will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Jalen Seal.
Afternoon, Your Honor.
Afternoon, Judge Mike Gaddy, Assistant Public Defender on behalf of Mr. Steele, who's approaching.
All right. You're requesting an adjournment. Mr.
Yes, Judge, I think there's some video that we might need to
Video.
look at.
Just go. Okay. January 20. Well, is the video, where's the video, given the charges and everything, what's going on there?
Your Honor, it appears to be, in watching the body cam video, it appears to be some kind of surveillance video that the police are watching with the hotel fella. So it's, I don't think it's body cam.
It's, okay. It's body cam of them seeing another video.
Right, so I kind of want the
I don't
video.
know if we have that.
I just want to see what they're watching.
Okay.
'Cause you
So
can't-
You know from the body cam that's been provided that they're watching the video, but you don't have the video that they're watching.
Right, and sometimes you can see it while they're watching, but not in this instance.
But not in this case. All right. January 29th, 2026, 9 a.m. bond.
Thank you.
Thank you, sir. Court calls case of the people versus Jonathan Smith.
Good afternoon, Your Honor.
Hannah Mackey for Mr. Smith, who is approaching. Please state your name.
Jonathan Smith. Thank you. Requesting an adjournment.
I am.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case of the people versus Angel Snow.
And on behalf of the people, this is public hearing on behalf of Ms. Snow, who's approaching now.
Ms. Snow, will you state your name for the record?
Angel Snow.
Thank you. Your Honor, we are having some plea negotiations with us for adjournment for that purpose.
Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case people versus Michael Umber.
Good afternoon, Your Honor. Raymond Cook, proceed.
Assistant Public Defender Chelsea Virgil with and on behalf of Michael Umber. Can you state your name?
Yes, Michael Lumber.
Thank you, sir.
You're welcome.
1 second, Your Honor.
All right.
Something? Okay. Can I approach, Your Honor?
Sure, come on. You need to take your hands out of your pockets. Sir.
All right.
All right, record should reflect you had a pre-funds conference in this case. And I will adjourn the probable cause in this matter. Are you on a tether at this point?
Yes.
You are, okay.
Yep.
Adjourn it to February 5th, 2026. 9 a.m. Bond will continue.
All right.
All right, thank you.
Sir.
Thank you, sir.
I have to say.
Court does call the case of the people versus Colin Vandermeud.
Brian Bowling on behalf of Mr. Vandermeud.
And Mr. Vandermeud, can you unmute and state your name for me?
Colin Vandermeud, sorry.
All right, thank you. Yes. Okay. All right, what are we doing?
Judge, working on some plea resolution negotiations, just need some more time. If I could get another adjourned pre-trial or a probable cause date, please.
Probable cause, I'll adjourn this to February 5th, 2026, 9 a.m. Bond will continue. All right?
Thank
you. All right. Thank you, Mr. Vandermeud.
You too.
Court calls case, people versus Terry, is it Van Tulen, maybe. I messed it all up. Who's their attorney? How did Mr. Virginia?
Hi.
Hello.
Yeah, Van Tynen. The U is silent.
Say it again.
Van Tynen. The U is silent.
The U is silent.
Yes.
Okay, I'm never going to remember that. I'll take your word for it. It's your name. All right.
Sorry, Your Honor.
You're like a squirrel. You're there, and then next thing you know, you're gone. And like you head across the road halfway, and then you go back. Where do you go between cases?
I don't know. At least
You're so fast. You're so quick.
At least you didn't call me a blind squirrel. I'll take it.
I did. Whoa.
Assistant Public Defender.
I would
Chelsea
never
Virgil,
insult squirrels with disabilities. All right, go ahead. What?
with and on behalf of Terry Van Tynen, who appears via Zoom, and I think she already stated her name.
She did, and then corrected me and yelled at me because the U's silent, and I knew that. All right, go ahead.
Now we are asking to adjourn the PCC to review the discovery with Ms. Van Tynen, who is in Grand Rapids.
All right. Do it. I don't have a problem with that. Do we have, are you aware of a bond violation?
Yes, I did discuss that with her. She's prepared to admit to not reporting to community corrections.
So she has not reported at all?
She has not, but she reports that she has been testing. She's on parole and provided me the contact information for a parole officer. I haven't been able to reach him, but I believe in a brief period of time, if the court gives us a couple of days, we can provide proof that she's been testing negatively. She tests weekly, I believe, for drugs and alcohol.
Okay, I'm not gonna have a problem with that, but she needs to get to our community corrections so that we can get the results. Okay,
Would the court give her until Monday?
yeah, how soon can you get out to community corrections, ma'am?
I thought it was Monday. I can't get out there till Tuesday.
Pardon?
I cannot get out there till Tuesday. I thought maybe Monday, but I can't get out there till Tuesday.
All right, so what I'm gonna do, the administrative bond violation, at this point, I'm gonna order that the defendant to report, well, to do a new order, to community corrections no later than close of business on, what's that, the 13th? On January 13th, 2026. All right?
Yes.
And then we'll deal with that, and maybe then we can get a release signed so we can get the test results, and then everything will be straight on. Okay?